number 13. I want some time, my lord. The appeal against equitable.
Other side informed. Other side informed.
Yes, yes, yes.
On a prayer made on behalf of the appellant. List after 2 weeks.
4 weeks.
Why 4 weeks? Let it be 2 weeks. 19 matters.
Yes.
My page, Your Lordship. Lordship, I'm paying for listing of 2 criminal appeals, Lordship, for orders on 7th of November.
Why do you want for others?
Lordship, already notice has been issued to the respondent against the POCSO Act, Lordship. Appellant was convicted
Appeal was admitted when?
in the month of May, Lordship. After
Oh,
this,
okay. Next week.
Please, the Lord, with the consent of others, I'd like to make item number 11, Lordship. To kindly pass for detail.
On a prayer made on behalf of the applicant appellant. List after a week. We thank you.
I didn't want.
May I please your lordship? My lord, it's a contested matter and the impugned order is at page 33. Petitioner has exhibited lordship voters list of 1966.
You are not there in this matter on record.
On record, I'm not there. I'm assisting my colleague.
Why aren't you there on record?
At that time, I was out of sector.
Could have signed the Wakalatama later on also.
Otherwise, my colleague will argue the matter.
No, see, if your colleague was not there, you would have, on instructions we allow, there is no problem. But matter of senior counsel is different. You should sign the Wakalatama. Okay, no problem. We make the arguments. Yes, what is it? Page
Impugned order is at page 33, lordship.
33.
Yes, lordship. Lordship, petitioner has exhibited voters list of 1966 of his father and other family members, 1970 lordship of his father and mother lordship. And from 66 was of
Page 33 is what?
is the impugned order lordship.
Okay.
66 is of one village lordship and from
We'll do one thing, we'll issue notice at this stage. Mr. Bang,
and lordship, I'll humbly pray for interim lordship because
interim, what apprehension do you have?
I might be arrested, lordship.
Immediately.
I might be arrested.
We'll have,
Lordship, because
we'll fix a date.
I have a very good case on because from 70 onwards,
We'll issue notice on the interim prayer.
70 onwards, same village lordship, mother is there and mother and petitioner is there from
We'll find that reason, the judgment has contains reasons. And
Yes.
to examine the reasons, of course, it's a part of judicial review, but it's not that judgment has been done, passed without any reasons. On the aspect of sufficiency of reasons, there's another matter. Whether we can go to the sufficiency, adequacy of reasons.
yes, lordship. But
Okay, we'll issue.
prima facie, I have a good case, lordship, for interim.
Miss, whose name should we record? H. Vetela,
Yes, lord.
heard Miss H. Vetela, learned counsel for the petitioner who has put to challenge a judgment dated opinion dated 6/4/2024 passed by the learned so-and-so in so-and-so, by which the petitioner has been declared as a foreigner / illegal migrant who had entered Assam on or after 25/3/1971. Full stop. Let notice be issued. Returnable on, give a date, Mr. Pang. Which FT? Borpeta.
This Borpeta, my
Corporate number 6.
2 weeks, my
Yes, returnable on. Today is what?
today 30.
30. Yes, when can we have it?
If your lordship calling for the record alone, so it may be 3 weeks.
Okay, we fix a date.
Yes.
We'll have it on 18th.
18 months,
18th.
18th of November.
18th. Union of India,
Lordship,
LDV. LDV, 1, state, Home Department,
Yes, 2, 6 and 7 I prepared.
J. Payang 2, 6 and 7. Election Commission, A. Ali,
So not 3.
3. And Mr. Taludar 4? 4, 5. Let extra copies be served upon the Learned Council within 2 working days. Let the records be called for. Notice is also issued on the prayer for interim order, which should be considered on the next date.
Lordship, the verification report I have annexed page 98, Lordship. There is no allegation. Even if I have post 1971, the inquiry officer has not mentioned anything, Lordship. So prima facie, I have a very good case for interim,
Therefore, we'll
Lordship.
consider.
From 70 onwards, same village, no shifting from 7 till date,
We'll
Lordship.
consider on the returnable date. That's why you've given a date, 18th.
Deep-
But take steps.
Yes,
Today itself.
Lordship.
So from tomorrow, you may not have a chance. We have given you 2 working days, but still take it, do it today itself.
Yes, Lordship.
Item 2.
May I please, your Lord?
Yes.
My lord, it's an ex parte order, Lordship. Notice was not received, Lordship. Page,
Let us see the opinion.
yes, opinion is at page 23, Lordship.
Failed to appeal to- Yes, what do you say, expert?
But the para page 25, my lord.
Yes.
That is the we, my lord, the base, that was the basis of we. The tribunal has passed in. This is the process of service of notice, my lord,
Yes.
has been described. He has proved the notice, the EO is present, he has examined the district. He has proved the notice.
Yes, what is your take on non-receipt of notice? What have
May
you
I
stated?
just read the process server report?
Yes,
Lordship?
where, please?
Page 30, Lordship,
30.
30, Lordship. মুতায়ন মতে আমি নোটিছত উল্লেখিত গাঁৱত গৈ নোটিছত নাম থকা মানুহজনীক বিষয়ে গাঁৱৰ গণ্যমান্য গণক ব্যক্তিক সোধপোছ কৰি কোনো চিনি জানি কোনোৱে চিনি জানি নাপাওঁ বুলি কওঁতে সেই গাঁৱৰ
What?
গাঁওবোৰ
What?
হোৱাত সেই গাঁৱৰ গাঁওবুঢ়া তথা পঞ্চায়ত চকীদাৰৰ মূল কপিত চহী লৈ ডুপ্লিকেট কপি তেওঁলোকৰ সন্মুখত বাজাজান গাঁও পঞ্চায়তত লটকা জাৰি কৰি মূল কপি মহামান্য আদালতত বিহিত ব্যৱস্থাৰ কাৰণে ঘূৰাই প্ৰেৰণ কৰা হ'ল।
When did you come to know about this judgment? How did you come to know about the judgment opinion?
From the Gaunbura Lordship. Recently, I came to know, I have mentioned in paragraph 6. Lordship.
Where do you stay? You don't stay in this address.
I stay the same address.
Then-
I have not shifted. I am in the same address, Lordship.
Where is the endorsement by the Gaunbura? Is there any endorsement? Mr. Payang?
The notice could be backside in the notice, my lord.
Hmm?
The backside is the
The
notice.
forms
with the-
control dicta,
Yeah.
No, Topon Chandra Deka is the process server.
Yes.
Ah, processor,
Page 30, my lord, Bhaktir Stuti, Dadot
Page-
Chandra,
Page
page 30, my
Ah,
lord, to the right side.
Pankaj Rajbangshi is there, Lordship. Right side, Sri Pankaj Rajbangshi.
Pankaj Das.
yes.
Yes, one
Dadot
Pankaj,
Das, Dadot Chandra Das.
Oh,
and Pankaj
Haki,
Das.
Haki Suhi.
yes, Lordship.
Otherwise, my lord, the section, the rule T5F provides that it should be in the conspicuous part of the house. That's decided.
Now, conspicuous part if the person is not found
Yes,
or the address is not found.
but if he is there, it's not proper.
Yeah. She says that there is no shift of the address.
Yes,
I don't
I'm
know
in
whether
the same
this-
address.
This is the service report.
Okay,
That is a matter of
okay.
fact.
Hard. In this case, you are there or not?
Yes, Lordship, I'm there.
But where's your name struck off in the? Why Whitener? Should maintain some transparency. Why these kind of things? See, let's see. Don't make this kind of things. Doesn't look good.
My name was reflected in the court.
That is okay, but why do you delete the name by use the user Whitener?
Clark. But this is, I have to undertake, no, if Clark also has done it, that I have to undertake, no? I'll just check the proper number. Kind of what is there. You know that.
Did you sign the Wakalatnama or not?
I'll just check the proper number first. Not there. My signature is not there. She is there, she can argue all the
No,
matter.
that is okay, but FT matters are otherwise also very sensitive. Why
Yes,
do you
most
make
of
this
the time last, while we have filed, I was out of station. So this might be the reason my name was.
But your
like that.
name is in the Wakalat, in the cause list, why? Tell us, what explanation do you have?
That lordship might be in the one form my name a clerk had put. This might be the reason. Otherwise, filed by everything was.
Page betala, huh? Same, order. Also, call for the area. তার খালি expert opinion হবো, expert এটা হয়ে যাব আর FT to বেলেগ হবো, হ্যাঁ, দারাং। তাৰপিছত Miss So Learned Council press for an interim order. Para. Or returnable date same, huh? Considering that the opinion is an ex parte one, comma, till the returnable date, that is so and so. No coercive action be taken pursuant to the impugned opinion.
Destabilized.
Records, thank you, back.
May it pleases your lordships. Lordship, impugn order is at page, starts from page 31 to 36, lordship.
36, yes.
Yes, lordship, and the petitioner has exhibited voters list of 1965, 70, 89, 97, 94, 2005,
Inter parte order.
contested matter, lordship.
Okay, we'll have same order for, that's the first one. We'll issue notice on the interim. Same date, okay? Take steps. Parties are the same?
Lordship, the date can be on 23rd of November because from 17 to 22, we are not there, lordship.
Whenever you say, 23rd.
23rd or 24, any date, lordship.
Okay, 24 to both are
Yes, sir.
holidays. Both are holidays. If you. can-
25th November.
25th, okay.
Yes, Lord.
25th.
Much-
First two matters would be on 18th. Or even those are to be
25th, lordship.
25th,
Yes, lord.
all matters 25th. Etu prothom to nisna. The area of parties, the respondents are the same?
Same.
Okay. Who are 5 and 6? 5 and 6 এর সাইল বারটা লোক
I'm from 4, 2, 7, 8 and 9.
লিখিলো নহলে আগতো তো লিখিলো ভাল নেকি নহলে কনফিউজ আগতো চাম
Second one is same, my lord.
Second one is same,
Same. Second one is same. my lord.
exactly same. This one,
This one is, my lord, I am appearing for two,
First Union of India,
Union
LDB,
one, my lord.
one Union of India, LDB.
Yes, I'm
And-
appearing for 2, 7, 8,
Item number 3.
and 9.
Payang 2, 7, 8 and 9,
Yes,
I picked that one number 3.
3. And Talukdar for 5 and 6. Okay.
Lordship, impugn order is at page 30, start from at page 30, Lordship.
30.
And- Yes, Lordship. And dated 29/20/21. Contested
21
matter,
matter.
contested matter, yes, Lord.
20, why are you challenging now? Why are you aggrieved now? You have not been aggrieved for the last 3 years.
Yes, Lordship. The group
would,
of lawyer who provide,
It would interim notice नहीं दिया. First part to. Same. Age better la. And area of parties same.
yes, Lordship,
Respondents are the same.
the
with different Lordship.
I'm appearing for 2,
LDB 1,
I'm appearing for 2, 6, and 7.
2, 6 and 7 Payang.
I picked that one number 3.
3 A Ali.
Talukdar will be 5.
5. Oh, LDB no, ever heard RKD Chaudhary. Yeah? Okay.
Lordship, the order is at page 35, Lordship. 34, start from 34 and at 44. Here the petition,
Yes.
this is also a contested matter, Lordship. And the
Olo-
petitioner here came,
Guwahati.
yes, Lordship, Guwahati. In FT1, Kamrup Metro.
Yes. What has happened here?
The person came from due to religious persecution, and that plea was taken in his WS and evidence lot.
What evidence did you adduce? What documents?
Documents are, Lordship, we have annexed voters list of 1966,
No, that he had come for,
71,
that he had come for religious persecution.
yes, Lordship.
You had said that he had come for religious persecution. Where is the document?
We have mentioned that the documents was destroyed. One document,
Destroyed.
yes, Lordship. One document is there, Lordship. Rest we have written in our page 50, we start from page 57, Lordship, written statement.
No, documents.
Document
Written statement will not do. Okay,
One-
same order,
129 page number,
same
Lordship.
order. Same order. Respondents are the same,
No, Lordship,
in the same order.
no, Lordship.
2, I'm appearing
1 RKD
1 for
Chaudhary,
Architect Students, 2
Two.
for 2, 6, and 7.
2, 6 same,
Yes,
2,
same.
6 and 7.
3 for
J
election.
Payang.
Yes,
Then 3 A Ali.
5 Talukdar.
Oh, 4.
4, my lord, we are taking instruction if you can appear, my lord. Because we have
4
not given
4 क्या लिखे लो प्रथम पाएंगे लिखे ना?
this. 4, my lord,
Then who is taking for 4?
my lord, for the time being, I can take, my lord, but just
Then for the time being, you are reflecting your name.
Yeah.
Okay. State coordinator.
Lordship, in the cost title, the 6, it should be DCP border, because in Kamrup it's DCP border. So inadvertently we have written SP border.
Madam, correction is not possible.
Yes,
on this.
we will file IA for the correction.
You
Lordship.
file a amended cost study.
Yes,
File an
please.
IA, then file an amended cost study.
Yes, Lordship.
For the time being, let it go like this.
Yes,
Wrong.
Lord.
Okay. Same date, 25th.
Yes, Lord. Much.
Notice on interim. Notice on interim. Please.
And then 6.
Here in this case, Lordship, on last occasion, I was direct to furnish copy to my learned friend, Lordship, who is appearing for the informant. I could not serve him on that day, but today I have served. So one alternate prayer, Lordship, if I may make, Lordship.
Mr. Das is for whom?
I'm for the application for the.
Informant.
Yes.
An amicus. Okay.
Only one alternate prayer, Lordship. The matter is of 2022. By keeping the IF pending, Lordship, in the meantime, they can file their objection. And if your Lordship fix a date for
The
hearing,
PB has been prepared.
paper will be
Yes.
prepared.
Yes, Your Lordship, we have received the paper book and we have also filed our objection against the I interlocutor.
And let him file the objection if you are inclined or if you want to take instructions.
Such plot begin, I did not have, so probably I just got the copy.
No,
of
you
it.
got a copy. At least you go through the
So I'll
copy.
go to the copy.
We can have his prayer considered on the next date. Let us, since he has filed an I, let us just have a cursory consideration. If we think that we go to the paper book and go for hearing, otherwise we'll consider the I, okay?
Right.
Sri A. Ahmed, Learned Counsel for the applicant, has informed that copy of the IA has been served upon Sri R.J. Das, Learned Amicus, for the respondent number 2 only today. Full stop. On the request of Sri Das, the Learned Amicus, matter is adjourned to be listed after a week. We fix a date?
Lordship.
List on. We have it on 6th of November. Is it okay?
Lord.
6th of November.
Keep low.
Obliged.
Well, in this matter, the paper book is ready, LTA is also there, matter may be fixed for hearing. I can get the paper book from the office, my lord. On the last occasion, I was called, but I could not get. Deacon,
Sri Deacon of Learned Counsel for the appellant submits that paper book, that though the paper book has been prepared, he is yet to collect the same, full stop. Let the paper books be collected by the
Paper-
concerned counsel and the matter be listed for orders to fix a date of hearing.
Lordship, yes.
service is come.
You've got the paper book. We have already said, Miss R. Gogoi, Learned Counsel, is present for the respondent number 2, who may also collect the paper book.
Public.
Or B. Bhuya likhi diba presence. Presence bilag likhi ba, huh? Agor guest to likhi ba. APP.
Item 8.
No, this is case of life imprisonment.
Paper book not yet prepared.
So,
LCR has come. I see.
Lordship, LTA is there, Lordship.
We direct,
With office note.
we direct preparation of the paper book.
Paper.
and my lord, we have IA for bail, so that may be considered along with that.
Okay, we are keeping it alive. Let the paper book.
I-
Heard Sri M.U. Mahmood, Learned Counsel for the
Different kind.
appellant, as well as Miss A.
No,
Begum,
no.
Learned APP,
So more I
Para?
was-
pursuant to the order dated 11/10/2023. The records have
Okay,
been
Mitra.
received. Para,
Okay, Mitra.
let the paper book be prepared expeditiously. And the matter be listed for orders.
The bail matter may be kept alive.
It's kept alive. We are not passing any orders.
Item 9.
Your amicus,
Legal aid.
legal aid for the respondent number 2. Copy of what has not been served upon you. This is an appeal, isn't it?
Appeal, ma'am, appeal admitted.
Appeal has been admitted. Let every paper book be prepared. You'll be given a copy of the paper book.
IA is pending for consideration.
Are you pressing the IA right now?
Lordship. This is
Then she has to be
final-
given a copy.
Lordship, I find it today, madam.
Oh,
Lordship may fix, my lord, on the next day. State has also not filed any objection. In the meantime, if they want, my lord.
okay.
Then you'll furnish copy to us.
So we are early learned counsel for the appellant applicant undertakes to serve a copy of the copies of the papers to Miss S. Khatonier, learned legal aid counsel appearing for the respondent number 2. Full stop. On request made on behalf of the learned counsel for the respondents list after 3 weeks to enable filing of objection to the IA.
Right. Wait, your lordship.
NIA,
NIA, my lord, appeal against rejection of a bail order, my lord.
okay.
NIA has already filed objection, my lord, we have received. Office notice showing that steps have not been taken, but we have already taken steps. They have also submitted their objection.
Are there any other respondents?
State, we have also furnished copies, my lord.
State who is appearing, Madam Bhuya? State is a party here.
Formal party maybe.
Formal party, my lord, but we have served copies to them also. So, my lord, may fix a date for hearing, my lord.
No, it's not in the concern section. Just a minute. Though there are office notes indicating that steps for service of notice have not been received by the concerned section, comma, this court has been informed that both the respondents, namely the NIA as well as the state of Assam, are duly represented. Full stop. Sri R. Okay. Sri R.K.D. Chaudhary, learned counsel for the NIA, has submitted that objection
Yes, we have filed.
has also been filed. Full stop. Yes, when do you consider?
My lord, November, any date, November, convenient to your lord.
A list on we'll have it on 18th of November.
18th of-
Okay,
That is-
18th of November.
18th.
The names of Ms. B. Bhuyan, learned APP. Your name, R.K.D. Chaudhary, is reflected or not? No. Yes.
SCN.
Name of name of PP Assam may also be reflected in the cause list.
Perhaps, hand copy of the trial court.
May be required.
Because, my lord, when the case was initially filed, at that time, depositions had not been recorded. Now, 9 witnesses have been examined. So, it's not basically.
No, that is on the other aspect of trial.
that
We are
is my
only examining the legality of
the
a
bail
bail order, only because it is a statutory provision. That is where we are hearing is an appeal. Otherwise, it's a
Yes,
bail.
bail.
Mm. If there is a requirement, we'll.
Basically, what is reflected in the charge sheet. Deeply obliged.
Item 17 and 18, sorry list. Oh, hearing. বাকি হয়ে গেল মানে অর্ডার গুলা হয়ে গেল
Kyle nine.
Hmm.
Kyle I want. Mr. Kyle.
Please inform Mr. Kyle.
He was, just I saw him, he was telling.
Mr. Bhattacharya. Mr. Chakraborty, for which matter? 14, that's reference. Okay. But there is another matter of Madam Mazumdar.
Yeah.
You ready with the matter? Your matter will take time because this is going to take some time, not too much, but we have not heard Mr. Kyle. Mr. Biswas has almost completed. You can come after.
Item 14, can it be taken up in the coming week? It does-
14. Where Mr. Chakraborty is there.
Yes, sir.
Chakraborty appears as what? Amicus?
No, but I am appearing, appeal we have filed, my lord, for the accused.
No, in the, okay, that's reference. Okay, you are the same person. Okay. One, you have filed an appeal also.
Criminal appeal, my lord.
Paper book.
We are in Diwali mood, my lord.
When?
In the coming week or up weeks.
Not inclined today.
Not very much.
FSL forwarding to.
Penalty?
Has to be there in some form, my lord.
Adjournment is not just for granted. There has to be a penalty imposed. We do not know in what form the penalty will be. Okay, on a joint request made on behalf of the parties, list after 2 weeks.
Correct.
This will be in item numbers
It will be item number 14 and 15.
14 and 15. Okay. Irukuntu. Irukuntu.
He's on election court number 12, he's coming up.
He said he had a one matter in court number 1 yesterday. If you
Yes.
remember correctly. First matter in court number 1.
Yes, sir.
That is over.
Okay, he is coming up.
Note down. He will take note of. whatever. My lord. My lord, today what I propose to do is that I'll just argue one point which I did not argue yesterday. And then I'll take your lordship to the judgment which I am relying on against each of my substantive as substantial arguments. My lord.
Yes.
Now, my lord. Section 55 compliance already I have argued, my lord. दे दो ये काम नहीं कर okay, print out. So, my lord, prosecution failed to relate. This was argued. No independent witness. Kitna point number? 5. Prosecution failed to. Yes. So, my lord, yesterday I argued that the FSL, the prosecution failed to relate the seized samples sent to the FSL with that of the contraband allegedly seized. The contraband which reached the FSL and the contraband which was seized, they have failed to relate both. And in support of this argument, my lord, my written argument, point number 5. There are two things, my lord. One is, if your lordship kindly comes to page number 100. Of the paper book.
Yes.
Page number 100 of the paper book is the FSL forwarding report, my lord.
No, this you have argued.
Yes, that the date and
Yes,
and that.
26.
Now, yes, absolutely, my lord. I just wanted to indicate the page numbers, my lord,
Yes.
that it was sent on 13 the important date is, my lord, when the samples were sent. That is mentioned in the first paragraph on 13th. So if this is sent on 13th, then how come, my lord, on 26th they make a prayer for next month, 26th they make a prayer for drawal of samples?
Yes.
Then which is this sample, my lord? Now, my lord, yesterday, my lord, your lordship has asked me, my lord, about the timing because the contrabands were in the possession, in the personal custody of the officer in charge. Now, my lord, the seizure completed at 9:30 p.m. My lord will kindly see the seizure list. At what time the seizure was completed? 9:30. Seizure list, your lordship will find at page number 92. My lord is there at page
92.
Yes. Yeah. My lord is there at page 92.
Yeah.
My lord will kindly turn to page 93.
92 is the scissor list.
Seizure list. Because to the pointed question which had fallen from your lordship yesterday, that when the seizure was done and when it was kept in the godown, the seizure started at 19:30, that is 7:30 in the evening, on 13/3 and completed 21:30.
This is supposed to be 13/9. 13/9.
9, my lord, 9. This is typographical.
Typographical.
I am not. 13/9. So 7:30 on 13/9 and completed at 21:30. 21:30 is 9:30 in the night. My lord has note.
Yes.
Now kindly come to page number 23, PW7. PW7 is the NCB Godown in charge. My lord, cross-examination part 1, 2, 3, 4. The fourth line from bottom, which starts with the word on 14/9/2018.
Yes.
On 14/9/20 at 11 p.m. samples was given to me to keep it in the NCB Godown. Teaching officer, can I teaching officer? Page number 2. Now, my lord,
Yes.
now when the seizing officer was put this question in his cross-examination at page number 17, the seizing
Now,
officer.
what about the next line? Sample was sent to FSL on
Yes.
15/9.
Sample was, my lord, that would be a separate argument. I'm just proving now, I'm arguing, my lord, because otherwise both will get mixed, my lord, because they are not clear when somebody is saying 13, somebody is saying 15, somebody is saying next month. That is my separate limb of argument, my lord. As of now, I'll just show that for more than 24 hours, the sample were in the personal custody of the police officer. Now, I have shown, my lord, when the seizure was complete.
Why did 24 hours? See, the seizure was completed on 21:30 hours.
Correct.
21:30.
Absolutely. On 13.
On 13. 21:30 means what?
9:30 in the night.
9:30 p.m.
PM.
It was not 24 hours. It was sent on 14/9 at 11 a.m.
AM. AM or PM? PM it is.
11 p.m.
PM. Cross-examination part, page number 23. Fourth line from bottom.
Original গন্ডগোল আছে আর এদিকে পেমেন্ট করে হেরি কথা বল বুঝে না পা his number
This is PW7. That is the person who, my lord, kept the samples on 14. Cross-examination part. My lord has found it. So, my lord, for more than 24 hours, it is in personal custody. When this question was put to him, the seizing officer, that did you give any explanation as to why you kept it? Why on 13th itself you have not kept this in the Gudam? What he has got to say, my lord, we'll see at page number 17.
17
17. The 13 itself, why you have not kept it? This is this is what he has said.
yes
Page 17, my lord will kindly come. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. 11 line from bottom, somewhere in the middle, on the right-hand side, on 14/9/2018, my lord has found, my lord will see. On 14/9/2018, I handed over the seized article to Udalguri PS Gudam. On the same day, I again handed over the original samples and money to NCB office. I did not submit the reason for not handing over the articles to Udalguri PS Gudam on 13/9/2018 itself. So he was in possession of the sample. Now, my lord, the question that emanates is this, my lord, whether it is permissible under the law, my lord. Mohanlal 2016 का मामला 2016 का copy. Now, my lord, the question is whether it is permissible under the law or not. I am relying on a 3-judge bench judgment of the Honorable Supreme Court straight away on this point, my lord. ये वाला नहीं, ये वाला 2018 वाला, Dr. Mohanlal 2018.
17 SCC 6 to 7
2018, 17 SCC,
6 to
6 to 7. Para
8 years said.
Yes, para 8.
This judgment has been overruled by.
This is the problem. I am not completed. This is not overruled. I will submit, my lord. This is not overruled. I know what is coming, my lord. It is overruled on what point? This judgment lays down, among other, one point, additional point it has laid down, that the informant cannot be the investigating officer. This judgment also, on that point, this judgment was overruled. Not on this point. This judgment was overruled on the point because this judgment says that a person who lodges the FIR, he cannot be the investigating officer. Now, on that point, because there were a large number of cases in the NCB department where the informant or the person who were a part of the raiding team, they became subsequently, they were appointed as the investigating officer. So this judgment says that a person who is a raiding team member or an informant, he cannot be an IO. That part of the judgment was overruled by a larger bench, but not this part which I am relying on. I am relying on section 55, nothing to do with who can be the IO of the case. Yes, 18, 8. Second copy. Now, the view taken by the High Court that section 55 of the NDPS, by the High Court, that under section 55 of the NDPS Act, that PW1 was empowered to keep the case property and samples in his individual safe custody is completely erroneous on the face of it. The provision reads as follows. This is section 55 has been reproduced here. And then the observation of the Honorable Court, my lord. A plain reading of the provision make it manifest that it is the duty of the police officer to deposit the seized material in the police station, Malkan. So he cannot keep it in his personal property. Straight away on this point.
No, but it was deposited. You are on the aspect of delay.
Delay.
This is not, it's not a case that he did not deposit. He had deposited.
No, my lord, he has deposited, but
Where is the violation of the mandate of law that he had kept in his safe custody, never deposited? Here is a case, there was a delay. You can very well argue on the aspect of delay. Why delay? But it's not a case that
my
it was
lord,
not
my lord,
deposited.
my lord, delayed deposit 10 amounts to, my lord, it is as good.
What is
Suppose,
the
my lord,
delay?
suppose, my lord,
No, what is the delay? 24 hours.
more than 24 hours.
It's not something, you can still argue, but it's not, this mandate will not come. This is a case where he did not even deposit.
My lord, this is a point of law which has been laid down, that
He
section
never
55.
deposited, yes.
Section 55, it says
Is it a
that,
case that it was not deposited? Or is it a case of late deposit?
now, my lord, the issue is, my lord, whether in view of the mandate of section 55,
Yes,
whether an IO or a police officer or an investigating agency, any officer,
yes.
can keep the seized ganja in his personal custody for more than 24 hours. Because the law says immediately you deposit it. My lord, will kindly take section 55 for a while, my lord.
55 is quoted here.
Section 55. Yes, it is quoted there.
Yes.
As office, section 5, police to take charge of the seize. An officer in charge of the police station shall take charge and keep in safe custody pending order of magistrate all articles seized under this act within the local area of the police station and which may be delivered to him, and shall allow the officer who may accompany such articles to the police station, who may be deputed for this purpose, to affix his seal to such articles or to make samples of and from them. So, my lord,
With what point are you trying to drive up from this? There's no point. You can argue on the delay, that's different, but it's not a case that it was never deposited. Its safe custody was given. There was a delay, you can still argue. But 55 has been complied with.
delayed I'll say delayed compliance of
You
section.
can modify your argument, but do not say that 55 is violated. There is no expression which you are trying to again introduce, that expeditious, immediately. There's no expression as such. Yes, it needs to be. But what is the delay? 24 hours. Is it fatal?
My lord, 24-hour delay, my lord, this will be.
This will lead to a different line of argument. You have not argued on that. You have simply said it was never deposited. That's not the fact.
No, I said, my lord, that it was in his personal custody for more than 24 hours.
We'll consider.
My lord, so, my lord, in my submission, my lord, samples cannot be in the personal custody more so when they have not deposited the seal in the Gudam. The seal was lying somewhere, my lord, at anybody's disposal to misuse it. Because, my lord, I will show a judgment of the Honorable Supreme Court which say that along with the samples, you put the seal in the Gudam unless the sample reaches the FSL, so that this seal cannot be tampered with in any other packet. Seal is the physical property of the court. It should be deposited in the Gudam. And, my lord, this seal should also be produced during trial because these are the physical properties of the court. Now, my lord, I'll move to my last limb of argument. My lord, in an NDPS case, my lord, if I understand correctly, the entire quantum of punishment is based on one fundamental thing, that is the quantum of seizure, a quantum of contraband being seized from the accused person. There are three categories, my lord: small quantity, intermediate quantity, and commercial quantity. Now, my lord, the prosecution will have to show by leading positive evidence that commercial quantity was recovered from X or commercial quantity or intermediate quantity or small quantity. They will have to prove it. Now, my lord, this case is 2 vehicles were intercepted and charges has not been framed under section 29. Neither conviction is given under section 29. Section 29 is in perimeter with section 120B of the IPC, that is conspiracy. There is no conspiracy charge framed. Individually convicted under section 21B, that is under commercial quantity. Now, my lord, therefore, my lord, one has to ascertain that whether commercial quantity, how much quantity of ganja is recovered because there are 2%. How much quantity of ganja is recovered from X and how much quantity is recovered from Y? Because there is no conspiracy. Two separate vehicles. Now, my lord, 102 kg they say in total. My lord, it is quite possible because, my lord, it is quite possible that I carry 19 kg and the other person carries the rest of the quantity. Now, the moment I carry 19 kg, I come below the commercial quantity. Now, my lord, let us see, to prove or attribute commercial quantity against the appellant, what evidence they have lead. Kindly come to page number. Page 6, PW1. Yes. My lord, page 6, 1, 2, 3. In between, my lord, where it starts with then the suspected cannabis. My lord, is there then the suspected cannabis?
Just a minute.
He's a member of the rating team.
Which starting from page?
My lord, it is 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10th line from top, which starts with then.
Yes.
Then the suspected ganja,
Suspected cannabis.
cannabis,
Yes.
within bracket ganja,
Yes.
and cash. Then the suspected cannabis were weighed in my presence and found 105 kg of contraband cannabis, which had been carried in the said 2 vehicles. Now, my lord, your lordship may skip the next line. Then exhibit 1 is the seizure list of 102.5 kilo ganja. My lord, where 3 kilo evaporated, I do not know. 102.5 kilo suspected cannabis. Now, my lord, will kindly see the cross-examination, page number 7. One, two, three, 4, 5, 6, 7, 8. 8 line from bottom, page number 7.
Just a minute, please.
Yes.
Yes, what is it?
Now, my lord, we see page number 7, cross-examination part of PW1. 8 line from bottom. I do not know.
Yes.
My lord, will see. I do not know which of the accused was driving which of the vehicle intercepted by us. My lord, is now, this is 1. Then PW5, that is the seizing officer. Page number 17, my lord, will kindly come. My lord, page number 17, that same old page, my lord. The second line from top. I did not mention in detail about the amount of ganja recovered from each vehicle and about the driver in the Panchnama. At the time of handing over to us, the accused, the vehicle and the packets were separately handed over.
Yes.
Now, PW 7, page 23.
Yes.
My lord, cross-examination part 1, 2, 3, 4, 5, fifth line.
Hmm.
In the compliance report, my lord. In the compliance report exhibit 14, it was not specifically mentioned from which vehicle what amount of ganja was recovered. So now, my lord, these are the evidences available before us with respect to how much contraband was recovered from which vehicle. And in my respectful submission, my lord, from these evidences, we cannot say what amount of ganja was recovered. If at all, my lord, those are ganjas, because the FSL report says it, these are, there is no report as such.
Yes.
Now, there is no conspiracy angle. There is no telephone pole registration, nothing of that sort, my lord. So, my lord, how do we know that this is a case which will fall under commercial quantity? And he's convicted under commercial quantity. Now, my lord, rest I have already argued. Caesar list, this FSL report I argued. Then samples drawn now. Now, my lord, the judgments which I am relying, I'll straight away come to the judgment. And seized ganja was never produced, neither there is any inventory. So we do not know whether at all any ganjas were recovered. There is nothing. The seized ganjas were never produced. Some goods were destroyed. We see some reference in the case record. Some contrabands were destroyed, my lord. What? Without obtaining any certificate, they have destroyed it. In 2016, 3 SCC 379. Each and every copy I'll give, my lord.
Name?
Acha. This is for, acha, this is, I got your point. This is with regard to once an FSL report,
Name.
my lord, this is 2022, my lord, there is a little change in the citation, my lord, because that was the later citation. She is correct, my lord. She has given me the first citation. This first citation is with regard to what happens if the FSL report goes. This is, though this, my lord, I should be fair enough, my lord, this judgment is in the pretext of a bail application. Punjab and Haryana High Court, my lord, because, my lord, without FSL report, very rarely cases has gone up to the Supreme Court, my lord. Because those cases ended at the Sessions Court level or at the High Court level. Because this is one of its kind, my lord, where without an FSL, without a valid FSL report, my lord, the cases come up to the High Court level. I have searched, but this judgment I could lay my hands on. This judgment is a recent judgment, my lord. So it is 2022 online, yes. Here, my lord, it says that if you file a charge sheet without an FSL report in an NDPS case, that would be constituted as an incomplete charge sheet because of the fact that, my lord, in an NDPS case, FSL report forms the basis of conviction. That is the basic document. Though this is, my lord, this is on a bail application, and now the Supreme Court
You are
is
citing a single bench of a High Court.
yes, my lord, because, my lord,
Please don't do this.
Achha, okay. My lord, I'll come to the Supreme Court decision. Union of India versus Mohanlal. 2016, 3 SCC, 379. That is samples to be drawn before magistrate, which has not been drawn.
The other one was also Mohanlal versus
Yes,
State of
there are
Punjab.
two Mohanlal.
This
One
is
is
16 is Mohanlal versus Union of India.
18 and 16 both are Mohanlal. This name Mohanlal is becoming very infamous when it comes to NDPS. Now, this case, my lord, 2063, my lord will kindly come to page, para number 31.1, my lord. I'll not take your lordship to all the narrations. Direct to the law laid down, my lord.
Paragraph?
Paragraph 31.1. It is the last page.
Last page.
Last page. These are the
Yes.
my lord, these are the laws with laid down by the Supreme Court with regard to seizure and inventory and sampling and all this. 31.1.
Please.
My lord, may I read it?
Please.
No sooner the seizure of any narcotic, drug and psychotropic and controlled substances and conveyances is effected, the same shall be forwarded to the officer in charge of the nearest police station. My lord, that is what section 55 interpretation by Supreme Court. Or to the officer empowered under section 53 of the Act. The officer concerned shall then approach the magistrate with an application under section 52A2 of the Act, which shall be allowed by the magistrate as soon as may be required under subsection 3 of section 52A. As discussed by us in the body of this judgment under the heading seizure and sampling, the sampling shall be done under the supervision of the magistrate as discussed in para 15 to 19. So 52A sampling must before the magistrate. This is the direction. Otherwise, in detail, the Supreme Court has discussed from para 15 to 19, but ultimately, this is the gist of the observation. The next judgment, my lord, is 2023 SCC Online Supreme Court 862. My lord is there, ma'am? Yes. My lord will kindly come. I am relying on para 3, 5, 6 and 14. Now, para 3 starts with a narration of section 52A, my lord. This part of the testimony has not been questioned whether, my lord, I'll get section 52A, the entire, it has been paraphrased, then para 5. Subsection 2 of section 52A of the NDPS Act mandates a competent officer to prepare an inventory of such narcotic drugs with adequate particulars. This has to be followed through an appropriate application to the magistrate concerned for the purpose of certifying the correctness of the inventory, taking relevant photographs in his presence and certifying them as true, or taking drawal of samples in his presence and due certification. Such an application can be filed for any of the aforesaid three purposes. The objective behind this provision is to have an element of supervision by the magistrate over the disposal of seized contraband. Such inventories, photographs, and list of samples drawn with the certification by magistrate would constitute as a primary evidence. Therefore, when there is a non-compliance of section 52A of the NDPS Act, where a certification of a magistrate is lacking, any inventory, photograph, or list of samples would not constitute primary evidence.
Yes.
Then, para 6 is also important. The rationale behind section 52A is there in para 6.
Para 6.
Para 6. It is
Yes.
the rationale behind it.
Yes.
The obvious reason behind this provision is to inject fair play in the process of investigation. Section 52A of the NDPS Act is a mandatory rule of evidence which requires the physical presence of a magistrate followed by an order facilitating his approval either for certifying an inventory or for a photograph taken apart from the list of samples drawn. In due compliance of Section 52A1 of the NDPS Act, the Ministry of Finance, Department of Revenue issued notification number such and such, which furnishes an exhaustive manner and mode of disposal of, my lord, I need not, because this is with regard to disposal. Now, para 14.
1-4.
1-4. Both the court below have mechanically placed reliance on the FSL report while taking the statement of PW11 as the gospel truth. The views expressed by him can at best be taken as an opinion at least on certain aspect. There are too many material irregularities which creates a serious doubt on the very case of the prosecution. On a proper analysis, we have no hesitation. Now, my lord, why I am relying on para 14? My lord, in para 14, my lord, our case is, if this case was better than our case. In para 40, in this case, at least there is an FSL report corroborated by the evidence of PW1. Supreme Court says once 52A is not complied, only you argue on an FSL report. This is at best, it is an opinion, will not go by this. You did not comply with other things. This will not help your case. At least this was a much better case than the present case. Then Simarjit Singh versus State of Punjab. My lord, in this case, the Honorable Apex Court has allowed the appeal on the singular ground of samples not being drawn before the magistrate. The Supreme Court did not go into any other aspect. Para 17 is relevant in this case.
Para 17.
17. The question of samples, the question of drawing of samples at the time of seizure, which more often than not take place in the absence of magistrate, does not in the above scheme of thing arises. There is so especially when, according to 52A4 of the Act, samples drawn and certified by the magistrate in compliance with subsection 2 and 3 of 52A above constitute primary evidence for the purpose of trial. Suffice is to say that there is no provision in the Act that mandates taking of sample at the time of seizure. That is perhaps why none of the states claim to have samples at the time of seizure. Hence the Act of PW7, para 9. Hence well, there is some, it is actually para 9. Para 17 is in fact a quotation from Mohanlal's case. Para 9 is the paragraph pertaining to this present case, Simarjit Singh. Hence the Act of PW7 of drawing samples from all the packets at the time of seizure is not in conformity with the law laid down by this court in the case of Mohanlal. This creates a serious doubt about the prosecution case that substance recovered was a contraband. Only on that singular ground.
It is paragraph 9 actually, not
Actually, paragraph 9.
17.
Because, yes, absolutely, my lord. I correct myself, my lord. I'm sorry. Paragraph 9. Solely on the brief basis of. Yes. Now, my lord, 2024, by former Chief Justice of our High Court, Justice Sandeep Mehta, my lord. 2024, 5 SCC 393. This is the latest. Para 26.
Muhammad Khalid.
Yes, Muhammad Khalid.
Para?
Para 26. Now here more harsh language is used, my lord. Para 26. At least in this case, there was a proper FSL report, but what the Supreme Court has stated, your lordship.
Yes, admittedly.
Admittedly, no proceeding under section 52A of the NDPS Act were undertaken by the investigating officer. PW 5 for preparing an inventory and obtaining samples in the presence of the jurisdictional magistrate. In this view of the matter, the FSL report, Exhibit P11 is nothing but a waste paper and cannot be read in evidence. At least they had an FSL report proper. Never produced before the. Now, my lord, I argued that the seized ganjas were never produced before the court. Now, my lord, what is the implication of not producing the ganjas, the physical ganjas before the court in an NDPS case? My lord, in all NDPS case, it is mandatory to produce the physical ganjas. My lord, the first judgment that I would like to press in service is 2013-14 SCC 527. Vijay Jain versus State of Madhya Pradesh. My lord will kindly come to para 12. We are thus, my lord is there, my lord?
Yes.
We are thus of the view that as the prosecution has not produced the brown sugar before the court and has not offered any explanation for non-production of the brown sugar alleged to have been seized from the appellant, and as the evidence of the witnesses to the seizure of the material does not establish the seizure of the brown sugar from the possession of the appellant, the judgment of the trial court convicting the appellant and the judgment of the High Court maintaining the conviction are not sustainable. So here, among other things, one of the factor was that the contraband seized were not produced before the court, which has gone against the prosecution. Now, the next judgment. The next judgment is on this point that the implication of not producing the physical contrabands before the court in an NDPS case, Jitendra, this is 2004-10 SCC 562. My lord, in a serial order against all these points in my written argument, I have already, my lord, I have mentioned this judgment against each head, my lord.
Paragraph?
Para 6. 6, no? Yes, para 6. In our view, the view taken by the High Court is unsustainable. In the trial, it was necessary for the prosecution to establish by cogent evidence that the alleged quantity of charas and ganja were seized from the possession of the accused. The best evidence would have been the seized materials, which ought to have been produced during the trial and marked as material objects. Material object. There is no explanation for this failure to produce them. Mere oral evidence as to their feature and production of Panchnama does not discharge the heavy burden which lies on the prosecution, particularly where the offense is punishable with stringent sentence as such as NDPS Act. In this case, we notice that Punch have turned hostile. This is regarding the Panchnama and the attributes of that particular case. But as a proposition of law, my lord, in an NDPS case, they ought to produce the physical evidence of the case, my lord. My lord, in fact, my lord, in all NCB trials in the
No, no, you
Kamrup,
have to read the next time also.
yes, my lord.
Under what context that has been required to be stated to be
Now-
essential.
Yes.
In that case, the punchers had turned hostile.
Ah.
So the punch
In this case, we notice that the punch have, my lord, in this case, first they say that in an NDPS trial, this has to be produced. That is the ratio part. The obita part, my lord, in this case, the punch have turned hostile. My lord, I will show the next judgment also. In different contexts, the same principle is used, that you produce the ganjas. My lord, invariably, the Learned Counsel for the NCB would also corroborate. Invariably,
No, if the quantity is a huge quantity.
yeah, the other day also your lordship has posed this question, my lord. My lord, invariably, I have been a part of trial where 400 kilos of ganjas were also intercepted. This is 130 kilos, 400. Invariably, in all cases where ganjas are intercepted, they produce this before the trial court. In at least I can say for Kamrup district. In all cases, what they do, my lord, they bring it in. But inside the court, they'll bring 2-3 packets. Then if the defense counsel raise an objection that these are not ganja, then they will tear one packet and they will show it. But if no such object, in all cases, my lord, because it is very, my lord, these are acts, my lord, where there are stringent provision, no suspension, no remission, nothing, my lord. Minimum sentences are prescribed. In bail, there is a draconian provision like 37. So Supreme Court says, this substantial compliance will not do. It has to be strict compliance. There is a judgment. There was a conception that substantially you have complied, it will go. Then came the era of strict compliance. Supreme Court says for certain acts where there are stringent provision, substantial compliance, some trapping of compliance will not do. It has to be strict. So, my lord, in this case also, the Supreme Court has taken cognizance of the fact that the physical ganjas were not produced before the court. Now the next judgment, my lord. In three judgment, in three different contexts, the same factor was taken into consideration by the Supreme Court, my lord. Now this judgment, the next judgment, which I'll be relying, my lord. In fact, my lord, this judgment, Noor Aga judgment, perhaps, my lord, no case on NDPS Act would be complete without a reference to this judgment. This is a very landmark judgment, 2008, 16 SCC, 417. To buttress this point, I straightaway take your lordship to para 85. This judgment has laid down, my lord, laws regarding many aspects of NDPS cases, my lord. One is the physical evidence of this case. Page 85, para 85. Copy here.
85.
85. Para 85, it starts with non-production of physical evidence.
Yes.
Now, my lord, have seen that heading, non-production of physical evidence?
Yes.
My lord. The prosecution alleged that 1.4 kg of heroin was concealed in a cardboard container for carrying grapes and was recovered from the appellant at such and such. Essential key items necessary to prove the same were. What are the essential? The cardboard cartoon allegedly used for carrying. They will have to produce that physical evidence. Second, the bulk which establishes the quantity recovered. The bulk of the contraband. The 3 homogeneous samples of 5 grams. Because, my lord, duplicate samples are drawn. This is the very purpose of drawing duplicate sample. One sample to the FSL, other sample to the court. That these are the same samples which I have shown it. And how to connect both the samples which I have sent to the FSL and produced to the court is the facsimile over it. We'll have to put the same facsimile over both categories of sample, original and duplicate. One goes to the FSL, the reminiscent comes back, the reminiscent should also be produced before the court. Then only we can connect. Otherwise, my lord, I draw a sample has been drawn. It is not ganja. Say, for example, hypothetically speaking, I change it in between. I send ganja to the FSL and I don't produce the physical evidence. I don't produce the duplicate samples. Then how do somebody know, my lord, that these are the same samples which were drawn in this case, which has reached the FSL? That is the purpose of drawing duplicate samples. That is why, my lord, production of all these three will prove the seizure of the ganja. One more paragraph. Para 85. Yes. So para 85, my lord, that is, my lord, non-production of physical evidence, what are required to be produced. The Supreme Court has clearly, my lord, within inverted comma, have indicated that if you produce 1, 2, 3, then you can say that it has been proved beyond all reasonable doubt. Now, the next judgment which I am relying is Vijay Pandey versus State of Uttar Pradesh, 2019, 18 SCC 215, para 8. Para 8. The failure of the prosecution in the present case to relate the seized sample with that seized from the appellant makes the case no different from failure to produce the seized sample itself. In the circumstance, the mere production of a laboratory report that the sample tested were narcotics cannot be conclusive proof by itself. The sample seized and the test have to be correlated. Now, in this case, how do we correlate? Here is a case, my lord, where somebody says the samples were sent on 13 to the FSL, somebody says 15, and their own court record says on 26th day. So how do we relate it, my lord? We can't relate that this is the sample which has actually reached there, because 43 days after the samples were alleged to have been received by the FSL, somebody makes an application on behalf of the NCB that kindly allow us to draw the samples and destroy the bulk evidence.
No, those explanation
My
we
lord.
take from Mr. Kyle. That time
My lord.
period is very
My lord,
slightly disturbing and alarming also.
my lord.
After the sample, as per the records, they've already reached, and we are not on the later aspect,
My lord.
what exhibits numbers were
My
given.
lord, my lord.
But why was the requirement of an application much thereafter? And in the order passed, there was no specific order of sending the samples. Order was also, perhaps there was some line missed out, because order was there for destruction of the seized materials, but it has to be preceded by first sending the sample. Something was left out. But the date, we are not only leaving out.
Yes, the date.
Date. And this is not corroborating with the date when the report was made.
And that is precisely why the FSL expert has not said anything regarding those exhibits.
Vijay Pandey's paragraph 8.
Yes, paragraph 8.
Vijay Jain has been again quoted.
Yes, Vijay Jain has again been quoted. That part. Next is State of Gujarat versus Ismail U. Haji Patel.
Why, on what content, what issue?
Yes, this is 2003 12 SCC paragraph. This is small judgment.
Why?
This is that you will have to show that the seizure sample, the relation between the FSL report and the seizure. And I'm relying on para 5 and 6.
If it's on the same point, no need.
No,
of-
no, no, my lord, it is also on the point where the samples, where the contrabands were kept. Because in this
Paragraph.
paragraph 5 and 6, my lord will say. Because, my lord, in this case, they have not exhibited any, my lord, this is one point, my lord, which perhaps I skip. In this case, moreover, my lord, no Gudam in charge was examined. Who has kept it? The bulk contraband. They say they have kept the bulk contraband in Udalguri Gudam. No Malkhana register, neither Gudam in charge.
No, somebody has said that it was.
That is the person in Guwahati in whose Gudam the samples were kept. Sample and the bulk. Bulk kept in Udalguri. Neither the Malkhana register of Udalguri PS nor the Malkhana register of NCB office Guwahati where the samples were kept were produced. The Malkhana in charge of Udalguri PS is not examined. The officer in charge of the Udalguri PS not examined. In my written argument, my lord, I have given all these things, my lord. Because section 55 say officer in charge will take this. Officer in charge should enter the dock and say, yes, it was handed over to me. I took charge of those contraband. Officer in charge not examined. Malkhana register not produced. So we do not know whether it was in the safe custody. They failed to prove safe custody of the contraband.
Okay, here in Gujarat case, which.
Yes, para 5. We find that there was really no material brought on record to show as to where the seized articles were kept. The High Court, after analyzing the evidence on record, came to hold that the identity of the articles sent for analysis was not established, and it was not established that the articles seized were in fact sent for chemical examination. In view of the judgment of this court in such and such versus such and such of the High Court is in order. The view of the High Court is in order. It is not the delay in sending the sample which is material. What has to be established is that the seized articles were in proper custody, in proper form, and the sample sent to the chemical analyst relate to the seized article. Para 6. Further, there was nothing brought on record to show as to under whose direction the samples were sent for chemical examination. Further, there was nothing brought on record to show as to under whose direction the samples were sent for chemical examination. The High Court relied on section 55 of the Act to hold that the absence of such information also vitiates the proceeding. Section 55 of the Act provides that the officer in charge of the police station has to take charge of and keep in safe custody the seized articles pending order of magistrate. Since there is no material to show that there was any order of the magistrate as to where the seized articles were to be kept, and there was no material to show that there was a safe custody as is required under section 55 of the Act, the view of the High Court is in order. The department challenged this, appeal was finally dismissed. On what context? Yes. Now, para 6. Now this is, my lord, I'm about to wrap up, my lord. This is page para 6. 2011 SCC 559, para 6. We must emphasize that in a prosecution relating to the Act, the question as to how and where the samples had been stored or as to when they had been dispatched or received in the laboratory is a matter of great importance on account of the huge penalty involved in these matters. The High Court was therefore, in our view, fully justified in holding that the sanctity of the samples had been compromised, which cast a doubt on the prosecution story. We accordingly feel that the judgment. This part, my lord, we must emphasize that how and where the samples had been stored or as to when it had been dispatched or received in the laboratory is a matter of great importance. Now, this is on the duty of the prosecution to produce Malkhana register to show that it was in fact kept in safe custody in view of the mandate of Section 55. This is State of Rajasthan versus Gurmail Singh, 2005 3 SCC 59, para 3. I'm just relying on one paragraph. That they will have to show the link evidence, which also, in other words, my lord, it is called as the chain of custody, my lord.
Paragraphs?
Para 3. Para 3, my lord, have seen, my lord? That- That's the, my lord, I'll not repeat it, my lord. It also emphasizes that the link evidence has to be established, my lord. The Malkhana register has to be produced, my lord. Then only they can discharge the heavy burden which lies on them in an NDPS case, my lord. As the legal principle goes, my lord, the more stringent the provision, the more strictness of proof is required. Now, lord, before parting with my submission, my lord, there is a, my lord, there is a reverse burden under NDPS Act, and the two sections are namely Section 35 and Section 54, like the Negotiable Instrument Act, my lord. Now, my lord, the reverse burden, before the reverse burden comes into play, my lord, the prosecution will have to establish the foundational facts in accordance with the procedure laid down under the NDPS Act and the rules framed thereunder, and in terms of the law laid down by the other judicial pronouncements, my lord. I am relying on, my lord, I'll not, my lord, take your lordship to each and every judgment, my lord. I'm just giving the para
No.
number and the judgment which
Why
says
is it required here?
not required, then I'm okay. So since there is a reverse button, my lord, there. So, my lord, just for record, my lord, I'm just giving one just for record that reverse burden will not come unless they produce the basic facts, my lord. This is 2018 2 SCC 305, para 5. There are better judgments also, my lord, but since your
2018?
lordship is the 2018 2 SCC 305, para 5. There are other judgments, but since your lordship is not doing it, Lord, I'll not.
One judgment you wanted to place, give it,
Oh, this is
that only that one. Because that may not be the issue involved.
Yes. In fact, the best judgment is Abdul Rashid Ibrahim Mansoori. This is the issue not involved, my lord. I'll not bother you. My lord, this is, and my lord will my lord, in my written argument, my lord, I have, in fact, all these judgments which I have referred, I have mentioned it in my written argument under each head. And I have in my written argument, the page numbers which your lordship will find, this page number relates to the paper book. That is what I'm so grateful, my lord. I'm deeply okay.
Please, your lordship, my lord. Please, your lordship, my lord. I am as a legal aid counsel appearing for the accused Sajan Karki, my lord.
There are two appeals.
There are two appeals, my lord. appeal number 91/22.
Just a minute, please.
Mhm. Good. Same paper book.
Yes.
Well, I adopt the arguments that advanced by my friend just now, Milord, and I will not repeat anything. I'll just point out only two
What is
things,
your appeal number?
my lord, is 91/22,
You appear as a legal aid counsel.
legal aid counsel. Sajan Karki, the accused name is.
91 of 2022.
Yes, ma'am.
Okay.
Well, the only two things while adopting all the arguments advanced by my friends, I'll just point out only two things, Milord, that day also I have pointed it out. Milord, that the main person who is the PW1, who is the PW2, Mr. Santosh Kumar, who was the person who informed and arranged for everything for interception of the contraband seized. His name is, that is at page 8, Milord, of the paper book. His name is Mr. Deputy Commandant Santosh Kumar, and he did not sign the statement. Therefore, my lord, in my all respectful submission, that his evidence perhaps has to be expanded. Number one, my lord. And number two, my lord, the case of an NDPS under the NDPS Act, my lord, is always foundationally based on the FSL report, drawing of samples and etc. And my friend has just now shown the judgment. I will not repeat that if the foundation goes, my lord, and 52A says that there must be a magistrate present, but the person who draw the sample at page 15, he himself said, I collected some small portion of the material from the 17 packets, and with the help of drug detection kit brought by us, the articles were examined and found positive. These are the samples he sent for FSL.
Page?
Page 15. 8 line from the top. Is the person who, without intimating the magistrate, he drawn the sample and sent it for FSL. He himself also examined by the kit, and these are the samples. This is how the samples were drawn. Now, therefore,
No, that sample is not relevant for you. The sample which is relevant for you is in the middle of the page.
yes, ma'am.
First, that is for his own personal satisfaction, that whether it is contraband. Then he collects, you still have a point. It starts with, then I collected 2 samples each of 25 gram.
Yes.
And these were the sample packets.
Yes, yes. Sorry, I'm so sorry. I'm grateful to Lordship. Then I collected 2 samples each, S1 to S17, D1 to D17. Here also, well, as your Lordship just rightly pointed out, magistrate was not there. Therefore, my lord, the compliance of section 52A is not there. And in my respectful submission, since the plaintiff of the whole case goes, then the subsequent all actions, statements, FSL reports does not help the prosecution. This is my respectful submission. And one, my lord, the principle of law that your Lordship is always aware and always appreciate, that when the punishment are harsh, the stringent provisions of stringent punishment is there, then the standard of proof is to be also heavier on the burden of the heavy burden on the side of the prosecution, and the procedural safeguards that has to be strictly complied. In this instant case, my lord, when the 52A is not complied with, then my lord, the all subsequent action codes, the subsequent reports confirming it to be a contraband, then also it will not help. One more point, my lord. Everybody is saying from the prosecution that from which vehicle, how much is the contraband seized was not mentioned. Very foundational facts are not clear and not coming forth with supporting evidence, corroborating evidence, which is admissible in law. That is why, my lord, the punishment cannot be continued. And in my respectful submission, with this perfunctory trial and perfunctory investigation, these two persons are kept behind the bars more than 6 years. That is a very serious matter to be looked into by this honorable court. I sincerely submit and respect it. Well, may take your loss. Will be my another matter is calling there.
Effects in the trial, not going to find any effect, but what's going to place the basic facts of the case. But we may come to page 95 of the paper. It is a panorama. How the NCB came into this case. I think has been written here. Page 95. The exhibit 2. Alright. Acting of information received from Sri Santosh Kumar, DC SSB 61 PN SSB, Bhairapon District, Vibalgodi, on 39/2018 at about 9:30 hours, that 900 chain has intercepted 102.500 kg of Ganja, that is in 17 packets, along with two persons, namely Deveshwar Vasumata, son of Transo, President Transo, and Sajan Karki. The information so received was reduced in writing and was submitted to Sri Dilip Kavita, Superintendent of NCB Guwahati Zonal Unit, for necessary direction. After that, a team consisting of me, Aninarjari, IO, Sri Kuldeep Kamar, IO, Sri Tapan Singha, IO, Sri T. Momin, Sepoy, Sri Praveen Chetia, Sepoy, and Sri Jugal Chandra Das, driver, and Sri Rajesh Thapa, driver, was consisted. After getting office order, the said team moved from CB Guwahati office at about 11:30 AM on 39/2018 and reached SSB 61 PN SSB Bhairapur at around 19 PM. Then approached Sri Santosh Kumar DC and introduced our team. Was given subsequently. He narrated us the whole sequence of perception and handed over me the recovered 102 kg of ganja in 17 packets, along with two persons and two vehicles bearing registration number 20. An item and other items as intervened. Then I approached Sri Santosh Kumar DC SSB to arrange two independent witnesses for the search, seizure, and proceeding. The two independent witnesses arranged from SSB staff are Sri Sam Kumar, Inspector SSB, 31st PN, permanent address Tanto, and Sri Marab Bagra. He is also SSI SSB. Then at about 19:30 hours, presence of two witnesses, I started search seizure procedure by open packet wrapped with white color polythene and taken out small amount of brown color flowering tape, feeling to be ganja, one packet, and tested with drug detection kit brought with NCB team and found positive test of cannabis ganja. Other 17 packets also worked with same white color polythene and covered with transparent polythene. Similarly, test was done for other packets also and found positive test of cannabis ganja. Then on reasonable belief that an offense has been committed under section 8C to be read with section 20B2C 29 and 29 of the NDPS Act, and all 17 packets of cannabis ganja and other recovered items documents were seized under section 43.8 NDPS Act, including two vehicles bearing number 20. Then all 17 packets were marked as given 1, 2, 3 to 17. Each of the packets was then weighted with the help of digital weighting machine brought by the NCB team in presence of two independent witnesses and two suspects. The weight of the packets were given as given below. Packet number 1 to then weight is mentioned up to 17. The weight of the suspected ganja was found to be 102.500 kg.
Why this 105 has become 102.5?
So that explanation is that is stated in witness. Ultimately, on I think by the CB team, it comes to 102, and weight of each packet has been mentioned. Then thereafter, two samples of 25 gram each were drawn from packets 1 and were marked as S1 and D1. Then it is stated two samples were drawn each from two packets that were marked separately. The next page.
This drawing of samples.
As per notification 1 of 89.
But
I'll come to that.
That has been.
Lordship,
said-
yes, there are,
said it will prevail.
there is some explanation. Lordship may accept, may not accept, but there are some explanation is there.
Explanation, yes, if it was impossible to get a maester or the
Lordship,
or the materials are such that if a sample was, it was not, sample was not taken at that moment.
that is not my submission. My submission on the basis of Mohanlal. There is an observation of Honorable Supreme Court in section 52A. Yes, that is there are judgment of Honorable Supreme Court that particularly section 52A2 has to be complied with while drawing the same. But one aspect was not considered by Honorable Supreme Court, subject to acceptance of my argument by law. I'll place that. After that, I'll place. Then on page 97. Two samples were drawn from each packet in compliance of standing order 1 of 89. That has been approved by the Honorable Supreme Court in all the judgment by this Honorable Court.
Which one?
Standing order 1 of 89. In Mohanlal also that was discussed, and in subsequent judgment, Lordship, that notification was not considered. However, in 22, the government has come with new notification, and that notification was, fiscal order was repeated. I'll place that up. And Lordship, page 97.
Notification number 1 of 89.
89. I'll place every consideration. Then page 97. Samples were mentioned here. Then sample S1, S2 to
Duplicate.
H17 are the original sample. D1 to D17 are the duplicate sample. Then all 34 numbers of samples, original duplicate of flooring of top believed to be ganja were kept inside envelope labeled and sealed with NCB brass seal number 4. Please to mark. And signature of the suspect of the two independent witness and seizing officer was taken on them after proper level. After drawing samples, all 17 packets with remaining contraband P1 to P17 were warped and marking cloth, swimming label and sealed with NCB brass seal number 4, and signature of the suspect of the two witnesses and seizing officers was taken on them after proper labeling. Rest of the items were seized mentioned and put below. A test memo was prepared on the spot and duly marked with NCB brass seal number 4 and signed by the two independent witness and suspect seized officer. Then page 98. The envelopes marked E1, M1, M2, and AB were also sealed with brass seal number 4, properly labeled in the presence of the two independent witness and suspect. The signature of the two independent witness and suspect of the seized were taken all envelopes in number 22. The search and seizure process was completed at about 21:30 hours on 39/2018 without causing any injury to any person and damage to any property. Then search cum seizure list was prepared on court at, this is important, 61 SSB camp at Bhairakund, Assam. Then notice under section 67 was sued to suspect so-and-so for recording their statement under section 67. The notice the one notice 57 was issued to suspect Satish Karki for recording his voluntary statement. So procedure was followed as per the standing order 1 of it. 2 samples were drawn. One argument was made that subsequently an application was made before the learned trial court after 40 days. But if that explanation is there, the judgment of the honorable court below, page 14.
49.
49. The part of judgment.
Yes.
If about 11 lines from below, page 49. Start from then compliance report.
Yes.
The compliance report under section 57 of NDPS Act was submitted to Superintendent of NCB Guwahati on 15/9/2018 by Sitting Officer Pani Nartek. Then a petition was submitted under section 52A for pre-trial disposal of the seized drugs in the court along with inventory enclosing copy of FSL report. Petition also submitted under section 52A for confiscation and disposal of the seized vehicle funds. That application was for drawing pre-trial disposal. That was allowed by the land trial court. Although it is not mentioned here, but if I can by produce the other sheet. That was in the month of about 40 days. Sample was drawn on the spot on the very same day on 13th, and it was sent on 15th. That has been clarified by the different witnesses. And let's say seizure was made in Bhairakund, not in Guwahati, the NCP.
No, the witness thereafter has not stated. A petition was submitted. That is whatever you have submitted, let us assume that it is correct. Huh?
What drawing of paid is
Thereafter, what happened?
That was allowed, Lord.
No. Where allowed?
Yeah, Lordship, from whatever my learned friend has submitted, that Lordship, here difference is there. Sample was drawn on the spot the same day.
We are not on that. We are with you.
Yes.
That those samples which were not drawn before a magistrate, let us for the time being, let us assume that it was drawn as per 1 of 89. Now they have also admitted that a petition was made before the learned court for drawal of samples. Pre-trial. Was it allowed?
Yes, Lord. It was allowed, Lord.
We have seen the record. It's not allowed.
Yes, Lord.
Not allowed.
2016.
I'm just, see the order of 30/10/2018.
I've not gone through the certificate. I was informed that
read the order. Something is missing here. The application was made on 26/10/2018. That's a handwritten the order, the receipt of the application. 26/10. And the order passed was on 30/10. 26/10/18 is the first receipt of the order of the learned court, wherein there is a mention of filing of the application. 26/10 is handwritten. Have you got? Order sheet, 26/10. 26/10.
26.
Yes, please read it.
CR put up today filing of the numbers of petition by diligence officer NCP.
Yes, 3 numbers. Okay.
Yes.
What is the first one?
The IO has read for allowing him to draw samples
Yes.
in process in the presence of the court. But the
This
court
is the this is the application you just referred by.
that cannot, that is not provided by the law.
This is the application which was referring the deposition, which
Yes,
you have
sir.
done just now read.
Correctness of the sample so that these drugs can be disposed of as per section 52A1 of the NDPS.
Hmm. This is the application.
Yes, sir.
And thereafter you read the order.
Right, petition number, right, another petition, the IO has prayed for allowing him to deposit the
amount.
seized currency of rupees 1,50,000.
1,50,000.
Official account of the NCP. Right, another petition number 20, IO has prayed for confiscation of the vehicle, 2 vehicles.
Hmm. 3 prayers, 3 petitions.
Yes,
Let us see the order passed.
the prayer, the proper head of the account of fixing 30/10/2018 for necessary order. Then 30/10.
Yes, read that.
The order arising out of the batch of petitions filed by Intelligence Officer Guwahati in connection with NCB crime number 20. The first petition relates to prayer for allowing intelligence officer to draw representative samples
Hmm.
in presence of the court and to certify the correctness of the list of samples drawn so as to facilitate disposal of the seized drugs
Hmm.
relating to certificate and samples as per section 52A of the NTPS.
Hmm.
In this regard, I have perused the case record and accordingly prayer is allowed
Hmm.
to dispose of the seized drugs
Yes.
in accordance with provision of 52A.
Where is the sampling?
So sampling, Lordship, this is not my argument also. My argument is that that was drawn as per the standing order 1 of 89, the very first day.
We are not on that. That we have understood. That first, you are saying that it was done as per the notification of 189. But this witness, he said that we had filed an application before the learned court for drawing of samples. Yes, this is the
No,
application.
please to see the petition. If the petition is available, Lordship, here the first petition, IO has prayed for allowing him to draw samples in the presence of court to certify the correctness of the sample so as to the seized drugs can be disposed of as per provision of service.
Was the drawing of samples allowed?
No, for, yes, Lordship.
Where?
For disposal, Lordship.
Where?
Yes,
Not disposal. It is only for disposal.
No, yes, for disposal.
Only for disposal. There is no sample.
No, Lordship. That is also my not submission also. For
There are 2 parts. First, allow us to draw samples, then for disposal.
that I,
Learned court did not even pass any orders for allowing
no,
samples.
that cannot be, Lord. My submission will be that cannot be. When Lordship application is made, court cannot allow such type of. Therefore, only disposal, for pre-trial disposal.
Why
That
it
was-
cannot be allowed?
Because Lordship, the Act does not provide for that. Even the notification does not provide for that.
Why Act does not provide?
Because Lordship, still order says that.
No, come to the statute.
Yes, Lord, I'm placing that. Section 52.
Yes. 52A.
Yes, 52A. Lordship, please to see the language.
Yes.
Section 52A, disposal of these narcotic drug and substances.
Come to 2.
Yes, Lordship, no, I'm placing 1 also because there is an importance to that. The central government may, having regard to the hazardous nature of health, vulnerability of the theft, substitution, constant of proper storage space, and any other relevant consideration in respect of narcotic drug, narcotic substance, controlled substance, or conveyance by notification in the official gazette. This, Lordship, please to mark by notification in official gazette. Specifies such narcotic drug, narcotic substance, controlled substance, or conveyance, or class of narcotic drug, or psychotic substance, class of controlled substance, or conveyance, which shall, as soon as may be after their seizure, be disposed of by such officer in such manner as the government may from time to time determine after following the procedure any accepted. Then 2. Where any narcotic substance or controlled substance has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53, the officer referred to in subsection 1 shall prepare an inventory of such narcotic drug, psychotic substance, controlled substance, or conveyance contained such detail relating to their description, quality, quantity, mode of taking, mark number, or such other identifying particulars of the narcotic drug, therapeutic substance and controlled substance or conveyance, or the taking in which they are picked, country of origin, other particulars as officer referred to in, he may consider relevant to the identity of substance control or substance or conveyance in any proceeding under this act, make an application to the magistrate for the purpose of A, certifying the correctness of the inventory so prepared, B, taking,
Or, don't miss the or.
yes,
Or,
taking the presence of such magistrate photograph and certifying such photograph as true, or C,
or.
yes, sir. C, allowing to draw representative samples of drugs or substance in presence of the such magistrate and certifying the correctness of any list of samples or drawn.
What
Okay.
about this? See,
Lordship, at the time of seizure,
yes, there only samples are to be drawn.
that is there. That is
So
not
this
been-
was the application made. Why are you saying the application cannot be made?
No,
No orders can be passed.
subsequently cannot be. But they have to make immediately, Lordship. That is also provided here.
Immediately they had not made. They had tried to say that we had made an application.
They have not made. They had made subsequently, Lord, for pre-trial disposal. This is the difference for drawing samples and making application under section 52(8)(2). That is quite different from A, Lord. That application was made for pre-trial disposal, not for sending the sample to the FSL. That is a basic. There is a difference between two things. This is my sample.
So what was the application made? Why do you need a sample to be?
No, Lordship, for pre-trial disposal, court permission is required.
No, why do you want a sample?
No, for the bulk has to be destroyed for the keeping the samples. Because there were initially
But
two
there is
samples.
no certification of.
Yes, there is no such. That is not, that is unnecessary. I will not make argument because there is no certificate. And this is my submission, Lordship, because there should be a notification. Now, Lordship, I am placing that Mohanlal paragraph 13. It is also important. Lordship, please to mark one thing, the special order 1/89 was discussed in this judgment.
Yes.
And Lordship, in none of the judgment, this was either held to be paid, or it was set aside. None of the judgment. Even in case of Mohanlal, 2016, Lordship, please to see paragraph 13, page 17.
You are citing Union of India.
Lordship, same judgment is cited by my learned friend also. This is quoted in 16 other journals also. I am submitting Lordship to today's site.
Paragraph.
Lordship, for appreciating, I'm directly coming to paragraph 13 law. Paragraph 13 last 5 lines. Because Lordship, there was a confusion with regard to special order 1/89, the provision of law. Because all the departments were following notification law. They were showing samples as per their content. So that's why Lordship, the matter went to Supreme Court for clarification. But one thing, Lordship, please to note that 52A was amended in 1989. When then, Lordship, the notification was followed by all the way. Paragraph 13, page 17, Lord.
Yes.
but the last 7 lines, not reading the entire. Suffice to say,
Yes.
suffice to say that there is no provision in the act that mandates taking of samples at the time of seizure. That is perhaps why none of the states claim to be taking samples at the time of seizure. But be that as may, a conflict between the statutory provision governing of taking samples and the standing order issued by the central government is evident when the two are placed in just position. There is no gainsay that such a conflict shall have to be resolved in favor of the statute on first principle of interpretation, but the continuance of the statutory notification is in present form is bound to create confusion in minds of the authorities concerned instead of helping them in discharging their duties. Next slide. The central government would therefore do well to re-examine the matter and take suitable steps in the above act. But if thereafter in 2022, a notification was issued with regard to collecting of samples and how to dispose of the same. What's you want to draw your attention to Rule 29, page 6, last page.
This is a notification dated.
What's if it is dated 23rd December 2022. And the rules call the narcotic drug and substituting substance seized, storage, sampling, and disposal rule to 2022. Rule 29. Repeal and SEBI. 29, last page.
Yes, please.
The standing order 1 of 88, dated 15th March 1988, standing order 2 of 88, dated 11 April 1988, issued by the Narcotic Control Bureau, standing order 1 of 89, dated 13th June 1989, issued by the Government of India, Ministry of Finance, Department and so. Then all these notifications are hereby repealed. Then 2. That is important. Notwithstanding such repeal, anything done or any action taken or purported to be have been done or taken under any of the standing order or notification repealed by sub-rule 1 shall, so far as is not inconsistent with the provision of these rules, be deemed to have done or taken under corresponding provision of this. None of the judgment subsequent to this aspect of matter was placed before the court, and it was it was not placed, was not to find any consent.
But Mohanlal itself has said that it once it needs a re-examination.
Yes.
So it has disapproved the notification 1 of 89. Because there was a statute, it's a conflict with the statute.
Yes, but that is my point. But if I want to add for a Lordship, this argument only for because even then, Lordship, the setting order 1 of 89 or other notifications were not satisfied by any of the judgment, even by the Mohanlal.
Is it required to be set aside?
Yes, but because even after recently, our High Court also passed an order, although the appeal was allowed. The observation that is some cases there by different bench, where it is observed that none of the provision of notification of 1 of 89 or section 50 was complied. But this is my consideration by a lot of people. So this is
now, how will it make a material difference in the decision-making process?
Because
was 1 of 89 fully complied with?
Yes, this is complied.
What is the requirement of 1 of 89?
It is mentioned in the Mohanlal.
Please.
I'm placing that part correct. Lordship, paragraph 11. paragraph 11, page 16.
Paragraph.
Paragraph 11. Section 52A1 of the NDPS Act empowers the central government to prescribe by a notification the procedure to be followed for seizure, storage, and disposal of drugs and psychotic substance. The central government have in exercise of their power through Spending Order 1 of 89, which prescribes the procedure to be followed while conducting seizure of the contraband. Two subsequent spending orders, one dated 10/5/2007 and other 10/16/2015, deal with disposal and destruction of the seized contraband and do not alter or aid the earlier spending order that prescribes the procedure for conducting seizure. Para 2.2 of the spending order 1 of 89 states that the samples must be taken from seized contraband on the spot at the time of recovery. Reads 2.2. All the packets containing cell serially numbered and kept in lots for sampling samples from narcotic drugs and psychotic substance. These shall be drawn on the spot of recovery in duplicate in presence of such witness Panchayat and persons from whose possession the drug is recovered, and mentioned in this effect should invariably be made in Panchanama drawn on the. That has been meticulously followed.
But you again read paragraph 13.
Yes, last.
No, not the last line.
Entire.
From not entire, from suffice.
Yes, suffice to say that there is no provision in the Act that mandates taking of samples at the time of seizure. That is perhaps why none of the states claim to be taking samples at the time of seizure. But that
Now, be that as it may,
may,
a conflict
conflict
between a
the
statutory provision
and governing taking the samples and spending order issued by the central government is evident when two are placed
in juxtaposition.
juxtaposition.
There is no gainsay
gainsay
that such a conflict
such a
shall have to be
conflict shall
resolved
be
in favor of the
resolved in favor
statute.
of the state.
Statute.
Yes, or on first principle of interpretation, but the continuation of the statutory notification in present form is bound to create confusion in the mind of the authorities concerned, instead of helping them in discharging their duties. Next slide.
You may not be able to accept your submission that till 2022, since
But
till the time of its repeal, it was still in force. It was not in force.
no, Lordship, thereafter,
By necessary implication, yeah, central government can do something for re-examining, which the central government had done in 2022.
Yeah.
But it is the statute which will govern the field, not the notification.
that is there, Lordship. I'm not making any submission contrary to the, I'm submitting on the basis of the observation made and the notification come out by the central. This is my small submission, Lord. So this
But
is
in no uncertain terms, it's been stated that as the first principles of interpretation, it is the continuation of statutory notification which will prevail over the.
that is there, Lordship. I'm not making any contrary my submission. I'm just placing this notification and my submission on the basis
But
of.
that notification provided for collection of sample at the site of the
on
the
the-
time of the seizure
Seizure.
itself. That is what was
Yeah,
done.
that has been done. And Lordship, one thing here, the SSP has intercepted. Thereafter, the city team at Guwahati was informed, then they went to the Bhairapkund. The time taken for reaching there and the deposit the sample in their godown, that is the explanation for this. And all this procedure was done at on the spot at Bhairapkund. So the submission was made that there was a delay, it was kept in the hand of the authorities. And Lordship, another thing, Lordship has seen when the samples were sent to the FSL, the seal was there, all these things were packed. Yes, there is a difference, but there is not anomalies in the report. Yes, while depositing the FSL official, he description, he has made some mistake. That is there. That cannot be said that the sample is different from when it was fixed. And other sample was, but in the report, Lordship, there is no anomaly.
This is even more damaging.
No, that is there, Lordship. In my humble submission. That
If
can be-
your submission, that would have been less damaging. This is even more damaging.
No, Lordship.
In his final analysis, he said, these are
No,
for,
no, Lordship, please to see the report.
we've seen
once
the
again.
report.
Everything is correct. And Lordship, in cross-examination also,
Everything is correct.
Lordship,
Everything is correct.
in report it is correct. Lordship, may please to see. Like, exhibit 3. Exhibit 3, page 99.
90?
Nine.
The problem will start there.
But in deposition description, Lordship, he has made mistake.
No. The problem will start there. The exhibit 3, page 99. Come
Yes.
to the deposition now.
Deposition, Lordship, there is a
No. Come to the deposition for another purpose.
deposition PW 4,
PW4.
PW 4, page 12.
Page 12.
On 59, 2018.
No, leave aside. The last part, you were trying to harp that the result of the examination that exhibit some wrong numbers have come, isn't it?
Yes, sir.
Okay, accept it for a time being. Let us turn over the page.
Which one, Lordship?
Please turn over the page.
Which page?
Same page, next page, 13. Turn over the page.
My report was forwarded by our then director. Exhibit 4
Exhibit 4.
is my report. Exhibit 4 is the forwarding letter.
Exhibit 4 is my report.
Yes.
Exhibit 4.1 is my signature.
Exhibit 5 is the
Please
forwarding.
show what is Exhibit 4.
Exhibit 4 is the forwarding letter. That is the,
Both sides. Something serious has happened here.
no, but Lordship report.
No, he has to prove the report.
No, that is there. I know Lordship simply.
And it's a criminal case. Even in a civil trial, a
Even
document has to be proved.
Even Lordship a document is produced that will not retain evidence.
I make a letter. Letter is a part of the records. But if I do not produce the letter, say something else,
That is
and mark exhibit something else, why?
that is there, Lord. That mistake is there. But regarding report and sample, that is matching. Yes, in during his deposition, he has committed mistake.
Deposition, how is it deposition? See this 5/9/2019, when when he was being examined. Have you seen the date 5/9/2019?
Yes, 5/9/2019.
And kindly turn to page 99.
Page 99. Please,
Page 99.
Yes, that should not.
5/9.
Yes, sir.
5/9. But see the number, exhibit 3.
It is not there.
No. Why we are slightly alarmed and disturbed is in while writing out the deposition, he writes exhibit 4.
Yes, that is.
But in marking, it is exhibit 3 with the same date, 5/9.
Yes, sir.
The date of the deposition, while he had deposed, this is the, but I would not know why, what has happened.
5/9. It's deposit on 5/9.
5/9.
46. The date is not mentioned by the land.
And interestingly, the same page 100, which is the next document, the chronology has also changed by one number. 3 has become 4, 4 has become 5.
That mistake has been. That is Lordship trial. It is a perfectly trial. And even Lordship in judgment also, what me please to see how the learned trial court. Okay, page 58. No mind has been applied. Only yes, just copied that and pasted.
And interestingly, you see, I'm just pointing it out to you. Paragraph, you are at page 13.
Page
13. My report was forwarded by our then director. Okay, 4 is my report, 4/1 is my signature.
Yes.
It should have been 3.
Yes.
Okay, then similarly 5 is the forwarding report, 5/1 is the signature of director. Correct?
Yes.
This should have been 4.
4.
Kindly turn to page 16.
Page 16.
Page 16, middle part.
Then,
Middle part, exhibit 5 is the authorization letter. Exactly on the middle, page 16, 16.
yes,
After exhibit 2, 9, 2, 10, 2, 11, 2, 12, with your signature, exhibit 5 is the authorization letter.
marking,
There are two exhibits 5.
marking, Lordship, trial is a very bad trial. And Lordship, when I was pointing out page 58, let me please just for
58.
58, description of article. Then copy from the deposition of.
58. Yes.
Middle for description of article, please seal the envelope. Marked as S1 to S13, S17, containing 25 grams dry plant material so and so. Result, same mistake has been committed by Matt.
No, trial court has to, whatever he has said, trial court, but see, but the next line is the trial court's own
Proved.
line. He has proved
proved
examination
ex-
report, exhibit 4 and exhibit 5.
Five.
This is not 4 and 5. Should
Yes,
have been
Dr.
at least, here it should have been 3 and 4.
Yes, Lordship, that is my point to be.
Blunder is in page 90,
Lordship,
the
another
trial court
thing-
judgment. Page 90 is the super blunder. The trial court is attributing this to exhibit to prosecution witness 3, whereas prosecution witness 3 has not exhibited any of these documents. So it is not just wrong in marking the number, there is also a doubt regarding who has exhibited this document. Kindly see page number 90, the prosecution exhibit, point number 3. Exhibit 3 and 4 are attributed to PW3. It cannot be attributed to PW3.
Here it has been corrected. Four and five, here 3 and 4.
It is attributed to prosecution witness 3, but prosecution witness 3 has not exhibited this. He is not the FSL person from the FSL. Person from the FSL is PW4.
Lordship, the trial, Lordship, overall, and Lordship, my place to mark. And PW4 was cross-examined. It is also important, Lord. The triplanet materials which I received examined as a whole. The whole materials are ganja, that is cannabis. No question has been put with regard to these animals. Both the sides, Lordship,
Musical break. Musical break.
Lordship, without wasting your Lordship time, it is the position of the type. With some explanation. And Lordship, with regard to Mohanlal, second Mohanlal. Interestingly, yes, there is a different point, but in that judgment it is said that that judgment is over by subsequent. Is 2020 10 STC page 120.
2020,
20 10 STC page 1,
2020, 10 SCC.
page 120. Party name is Mukesh Singh versus State NCP Narcotic Branch Delhi. This by 5 judges bench.
What has been stated here?
It has been stated that Mohanlal has been over. Yes, that point was referred to full bench with regard to whether IO and SMP is similar. But so while this overruling, that judgment has been said to be overruled by para number 1. What about Lordship? Because Lordship has not convinced with the argument of the with regard to deposit of samples. There is a delay. There is explanation Lordship because the seizure was made in Bhairapun and it was deposited in Guwahati, the NCPO. So overall Lordship, this is the position of the trial.
That's what, Mr.
Yes, sir.
Mr. Biswas, what Mr. Kyle is trying to urge is that no doubt in Union of India versus Mohanlal,
Hmm.
1 of 89 was dealt with.
He's not referring to this Mohanlal.
Mohanlal, Union of India versus Mohanlal, 2016,
Mhm.
3 SSs, 379.
Hmm.
Notification 1 of 89 was dealt with.
Hmm.
And he says that though some observation was made
Hmm.
that it will be the statute which will override any notification,
Hmm.
but it was not specifically held to be ultra vires the statute. Rather, there was an observation that it was for the legislature to take a call on this. And so, and 1 of 89 provides that at the time of making the seizures, you can, at that spot only, you have to take the samples. So there was no error in law. That was his urging.
Could I respond to that, madam?
And if you take the sample at the same spot, the presence of the magistrate, that is what is.
My lord, the 2016 Mohanlal judgment clearly says that the standing instruction 1/89, to the extent that to the extent as it talks of drawing sample at the spot, that part is held to be ultra virus in view of the act. Number one. Well,
It's not been said ultra virus. There is a necessary implication is there, but still then, the repeal came only in the year 2022. It existed in the statute book.
My lord, no, that notification was issued by the government.
It existed in the statute book. It existed.
Statute book.
Not statute book, the notification existed. It was
Yes.
repealed by 2022 rules.
Now, my lord, to whatever subject to correction, my lord, to whatever I understand, the basic difference between a law being held to be ultra virus and an amendment is that once the law is held ultra virus, it is ultra virus since its inception.
No,
It was a
there-
bad
there
thing.
there is no ultra virus. There is nothing. It was,
My lord,
in
that
fact,
was-
that was not even the subject matter of challenge. It was a passing remark, yes. And there is no dispute to this, that it will be, it is the statute which will prevail
Yes.
over a notification.
Yes.
But having said that, the central government would therefore do well to re-examine the matter and take suitable steps in the above direction. And this ultimately was taken care of only in the year 2022 by the framing of a rules of 2022, where under the repeal column, this notification has been repealed.
My lord, in the subsequent judgments which have
No,
played,
that will not mean that this notification still have anything to do. It is the statute. There is no.
now, my lord,
Second opinion about that.
against this argument, my lord, my answer would be this, my lord.
But it is a kind of a technical kind of an argument that it was existing. Notification was
Yes.
there.
My lord, a notification in existence which has been declared to be against an statute by the Supreme Court, read with Article 135 of the Constitution, once Supreme Court says that it is meant, you will have to take it in 2016, it is saying.
What is 135?
That a law declared by the Article 135, my lord, that a law declared by the Supreme Court would be binding on the entire territory of India.
135.
141, sorry, sir. 141, 141. Okay. So this is 141. So now, my lord, therefore, my lord, in 2016, Supreme Court says in para 131.1 that samples has to be drawn in the presence of a magistrate. Now, should I go by that law or a notification of 1989? Because here Caesar was post 2016. That is why I said Article 141. Caesar is post 2016. I can understand an argument where Caesar is pre 2016. That though that law was not laid down. Here it is 2018 and this Mohanlal is 2016. In fact, my lord, in my limited understanding, Mohanlal have not said anything new. Mohanlal have just reiterated and re-emphasized the provision of section 52 capital A subsection 2 clause small c.
This introduction of the this amendments of 52A, when is it done? Huh?
That will long back.
No. Thereafter, some new insertion after 52A was inserted in 89. Thereafter,
Yes.
in 2014 also.
So
Some,
that's, my lord, 2014, but, 2004, such drug, the word such drug was substituted, narcotic drug and psychotropic substance were substituted. These are, my lord, minor amendments, and in all cases, my lord, these are all pre-2018. For this case, it was all pre-2018. Nothing after seizure. The judgment is before seizure, the act is before seizure, all is before seizure. So, my lord,
52 was acted in 1989.
89, way back.
29.
it was there in the,
Yes.
it's a part of the NDPS Act,
Yes.
long time back.
Yes. Only
This
on
act came into being in 1985,
Yes,
89, the amendment
That
52A.
was my submission, Lordship. It was 89. Up to 2016, special that special order was for till it was interpreted by the Supreme Court in 2016. And it
No,
was
you have said that subsection 1 gives the power to the central government to
yes,
have a gazette
Notification.
notification, which you have done, 1 of 89.
Yes.
And this 1 of 89,
was
and
repealed.
first time the Honorable Supreme Court in the case of
Interpret-
Union of India Mohanlal
Hmm.
found that it was in conflict with the statute.
Yes,
Absolutely.
that is there. But it was repealed in 2020.
But
That's a
present,
mechanical thing.
Hmm.
That's
Yes,
a
Dr.
mechanical thing.
I'll just add to one submission, my lord, only rebutting what my learned NCB council
Okay,
have argued.
have we completed?
Complete, my lord, 30 seconds, my lord, I'll complete. My lord, one argument was made that cross-examination of PW4, that this cross-examination, my lord, why do I cross on an expect?
What did he say? He did not say anything.
So why should I cross
No,
him and?
he has not anything.
No, my lord, the submission was made that in cross-examination, we have not said anything. So why
No,
should
no.
we cross on that
Did you
aspect?
say, did you make such a submission? No. No such submission.
Then it's fine, my lord. And
Lordship, recently what happened, Lordship, remember that in case of Benami transaction, Supreme Court has set aside provision of 1998.
Which one?
In Benami Transaction Provision Act, in Ganpati Telecom. Lordship, recently what happened last week, that the judgment was reviewed at the Honorable Supreme Court. Observation made by the Supreme Court that when a particular provision was not challenged, court cannot touch that. So on that provision, Lordship, the judgment was recalled.
Because there was not the specific matter of challenge.
Yes. So here also in this case also Lordship, notification of 89 was not found as a challenge. Yes, that was interpreted. That is there, Lordship. Technical, my argument is only on technical.
No, though it was left to the legislature to do the needful in necessary implication, it was said, and otherwise also, the state cannot be held to be.
That is there, Lordship. I am not making any.
Okay.
now, my lord, another argument was that there is an FSL report. So though the PW4 have stated the description to be different, but FSL report it is correctly mentioned. My lord, if that be the law, my lord, how do we
No,
prove it?
that you not argue.
Absolutely, I'm deeply.
Somebody has written something, unless it's proved in accordance with
Absolutely.
law, you're not taking cognizance of that.
Absolutely. I'm deeply.
Each huh? In the each Biswas in one of the cases. You are in which one? 97. You are in 97, Mr.
My lord,
Biswas?
number is 91.
No, you are in 97.
97, I mean.
M. Biswas are 90 and A. Chamwa, Legal Aid Council in 91. And SC Kyle, NIA Council, Training Council NIA.
Special
NCB.
prosecutor,
Special,
NCB.
Special Public Prosecutor, NCB. Okay. Reserve for you.
My lord, happy Diwali, my lord.
Our best wishes to, we are still here. We are not going anywhere. If you can go, we do not have the liberty to go. 2 o'clock.
Matrices, the lordship. Lordship, the expired lordship is at page 4. Herein the
Offense
son,
under?
30, he killed his father and he had cut his father's head, taken it in a bag, had cut the penis and also some fingers, 2 fingers, legs and middle, and his own. Just read the FIR. Humble submission is that around 5 a.m. on 14th.
Just to give us 1 minute.
Yes.
Which district?
It is Udalguri. PTA.
You appear as amicus or?
Yes, Lordship, I'm Mike.
Yes, please.
FIR is at page 4. Humble submission is that around 5 a.m. on 14/3/2016 today, while getting up from bed, I saw a blood-stained bicycle and a bag containing a severe human head in our courtyard. I immediately informed the local Gampura village headman, and making a search, I found the accused name below lying in the field located in the backside of our house. On being asked, he replied that he had beheaded his father at his own residence at Jagyapur and had brought the head in a bag. As said by the accused, some unknown person had cut his penis. Therefore, I request you to take necessary action in this regard. Then, Lordship, he was committed and PW1, Lordship.
This Bhim is PW1.
PW1, he's the informant. He gave the FIR. He says, I am the informant of this case. I know accused Ganesh Monkey Munda, who is present in the dock today. The occurrence took place at about 3 months ago. Accused is my related brother. My mother and the mother of the accused are sister of each other. On the day of occurrence in the morning at about 5:30 a.m., I saw a bicycle in our veranda kept against the house wall. There was blood stain in the bicycle. Nearby the cycle, a bag was lying, which was also having blood stain. Said bag contained a human head. I then informed the matter to our village headman over phone. The village headman came to our house on getting information given by me. There were blood marks in our house premises, and following the blood marks, we proceeded towards the rear side of our house premises. And after proceeding about half kilometer, we found accused person sitting nearby a road and enjoying burning flame. In the meantime, police came. On being asked by police, accused confessed that, Lordship, this is a part I would again refer to later on, because in front of the police, the confession. Confessed that he beheaded his father and had taken the head in a bag. He also confessed that he carried the head of his father riding a bicycle and kept the said bicycle and the bag containing the head at our veranda. I lodged the FIR before the police of Majpat PS. Exhibit 1 is the FIR and Exhibit 11 is my signature. Police seized the aforesaid bicycle in my presence. Exhibit 2 is the seizure list and Exhibit 2-1 is my signature. Police took out the head from the bag. I identified the head to be of deceased Pius Munda, the father of the accused. Our family members also identified the head to be of Pius Munda. Police took the head to the house of the accused person. Police apprehended the accused person and took him to his house. I, along with others, also accompanied the police to the house of the accused. We found the remaining part of the body of Pius Munda inside the room of the house. Police recovered one axe having bamboo handle and one sickle having wooden handle from the house of the accused person, and the same was seized in our presence. Exhibit 3 is the sales Caesar list and Exhibit 3.1 is my signature. The executive magistrate came to the place of occurrence and held inquest over the dead body. At the time of inquest, I was also present there. An inquest report was prepared by the executive magistrate and I put my signature in the inquest report. While proceeding following the blood mark, we found a penis with 2 testicles. We showed the same to the police and police took them along with the cut head to the police station. Then in cross he says, while police was asking him about the occurrence, accused told the police that his private part was also completely cut by somebody. We noticed bleeding from the person of the accused. I did not witness who kept the bicycle and the bag containing the head on our veranda. I do not know the owner of the seized bicycle. I do not know whether the accused person killed his father. It is not a fact that the accused person did not confess before the police, as stated by me, to have killed his father by beheading him. I do not know whether the seized axe and sickle were used in the occurrence. There is no house in the right side of the house.
There is one house.
There is one house in the right side of the house of the accused at a distance of about 5 meters. There is another house to the left side of the house of the accused at a distance of about 15 meters. When we came to the house of the accused, other people also gathered there. It is not a fact that the accused have been falsely implicated in this case. In fact, in this case, there is no eyewitness. But in 313, again, the accused is revealing certain things. He is accepting. So, PW2 is Sri Indra Bhumej. He says, I know informant Bhim Korang. I also know accused Monkey Munda, Ganesh Monkey Munda, who is present in the dock today. Victim Piyush Munda was the father of the accused. The incident occurred in the month of March of this year. My house is situated at a distance of 1 furlong from the house of the accused. On the next morning of the occurrence at about 5:30 a.m., while I was proceeding to riverbank to attend call of nature, I met Ajay Munda, who told me that somebody assaulted accused Ganesh Munda and there was some blood stain in his house. After attending call of nature, I came to the house of the accused person, but I did not find accused in his house. I saw blood marks in front of the door of the house of the accused. I suspected something wrong. I called one Nepali person, Sri Gal Bahadur Vishwakarma. I, along with Gal Bahadur Vishwakarma, came to went to Jagyapur petrol post and informed the matter to the in charge of that police petrol post. We, along with police personnel, came to the house of the accused. The door of the house was locked from outside. Police, by the force of torch light, saw a dead body inside the room. The head of the dead body was not seen there. Police then informed the matter to Majbat PS and police of Majbat PS came to the place of occurrence and they apprehended the accused at village Kusurabari. Police asked us to open the door of the room and accordingly I, along with a Safaiwala, opened the door and took out the beheaded dead body to the courtyard. The dead body was found lying on the floor of the room. An axe with blood stain was found lying beside the dead body and a sickle was also found beneath the bed. The sickle was also having blood stain. Executive magistrate held inquest over the dead body at the courtyard of the accused. I came to know that head of the dead body was recovered by the police from the house of another person. Executive magistrate prepared the inquest report wherein I put my signature. Police seized the aforesaid axe and sickle in our presence. In cross, he says, there are houses of a Bodo people and a Nepali people nearby the house of the accused. When I visited the house of the accused person, I did not find him there. I came to know that the accused sustained injury on his person. I came to know that accused was taken to mental hospital, Tezpur, by his elder brother. Lordship, this also later on I'll be submitting something on this part of mental health. PW3 is Sri Dharmalal Giri. He says, I know accused Ganesh Monkey Munda. I am village headman, government Gaumbuda. The locality of the accused falls under my village headmanship. The occurrence took place on 14/3/16 at around 5 a.m. ASI of police Dulal Chandra Das informed me over phone that Piyush Munda has been killed by his son Ganesh Monkey Munda. I came to the place of occurrence, that is the house of the deceased, and saw the dead body inside the room lying on the floor. The dead body was headless. The head of the dead body was recovered in another place. I noticed one axe and one sickle beside the dead body. Those were bloodstained. Police seized the axe and sickle. Exhibit 3 is the Caesar list. Exhibit 3-2 is my signature. By defense in cross, he says, it is not a fact that I did not state to police that ASI Dulal Chandra Das informed me over telephone that the accused killed his father. The house of Dal Bahadur Biswakarma is situated to the northern side of the house of accused at a distance of about 50 to 60 meters. Dal Bahadur Biswakarma told me that he did not heard any halla. Accused spread rumor that 4 unknown persons came to the village. PW4 is Lokimoni Orang. He says, I know accused Ganesh Monkey Munda. He is my nephew. Informant is my son. The occurrence took place about 1 year ago. Accused brought a head of a person separated from body to my house in a polythene bag. I informed village headmen and police. Thereafter, village headmen and police came. The head was of accused father Pius Munda. Police took the head to the police station along with the accused. In cross, he said, I did not see who brought the head separated from body to my house. I did not see who beheaded my brother-in-law Pius Munda. PW5 is Lal Bahadur Biswakarma. He says, I know accused Ganesh Monkey Munda. I also know the informant. The occurrence took place about 1 year ago. On the day of occurrence, Indra Bhumish called me to the house of accused. I went to the house of accused and saw blood in the courtyard of accused. Thereafter, police and village headmen came to the house of the accused. The beheaded dead, it should be dead, I think. Dead body was found inside the house. On search, head was found in the house of Himorang. I do not know who killed the deceased. There was no cross of this witness. PW6 is the doctor lordship who performed the postmortem exam. And Dr. Bhadrakanta Sarma. On 14/3/16, while I was working as MNHO Udalguri Civil Hospital, I have performed postmortem upon the dead body of Pius Munda alias Chotua Munda in connection with Masbat TS case number so and so under section 302 IPC. The dead body was identified by Gopal Datta. On examination, I found the following: external appearance, this lordship wound is several aberration on the anterior chest wall. 2 fingers in the middle finger are amputated from the right hand. Heavy laceration on neck and face and decapitated head. Then lordship about skull and spinal canal is mentioned. Then other injuries lordship will find more detailed description lordship. Several aberration on the anterior chest wall, amputation index and middle finger of right hand, amputated penis at bone and scrotum, heavy laceration on neck and face seen, and decapitated head. Dissection spinal cord at cervical level. Opinion. In my opinion, death is due to shock and hemorrhage due to the severe injury in neck with disapplication of head, and all the injuries are antemortem. Time since death approximately is 10 to 14 hours. Exhibit 4 is my postmortem report and 4 my signature. No cross-examination of this witness. Then lordship PW7 is Bhadreswar Panik. I am the village headman of Kushrapari village. I know accused Ganesh Monkey Munda, informant and the deceased. The occurrence took place on 4/3/16 at about 5 a.m. The chokidar of our village, Kartik Orang, came to my house and informed me that a cut head of human body is kept in the house of his father. The cut head is the head of Pius Monkey Munda. I asked him where the person who brought the cut head to his father's house. On being asked, he said that he fled away. The name of the person is Ganesh Monkey Munda. I found the accused lying on the road. On being asked, he confessed that he killed his father. Then I informed police. Police came to the place of occurrence. The accused confessed before the police. Police opened the bag and found the cut head of Pius Monkey Munda. Police seized the cut head and bicycle in my presence. I went along with the police to the house of accused. I saw the beheaded body of the father of the accused lying inside the house. Exhibit 2 is Caesar list, 2 my signature. In cross, he says the accused was lying smeared with blood. On being opened his pant, we found his penis was amputated. I do not know where from the cut head was brought. It is not a fact that I did not state before the police that accused made confession before me. It is not a fact that accused did not confess before the police. PW8 Lordship is Ajay Monkey Munda. I know accused Ganesh Monkey Munda, informant and the deceased. The occurrence took place in the year 2016. I saw that accused Ganesh Monkey Munda was lying on the court. The chokidar of our village informed village headman. Local people gathered. On being asked, the accused confessed before the local people that quarrel took place between him and his deceased father. In the course of quarrel, he killed his father. In cross, he says, I did not see the cut head, and I do not know where from the cut head was brought. When I saw the accused, I noticed blood was oozing out from his head. When I saw the noticed blood was oozing out from his head. It is not a fact that accused did not confess before me and local people. PW9 is Dulal Chandra Das. He says, at the time of occurrence, I was posted at Jagdapur PP under Majbat CS. I know the accused person, informant and the deceased. On the day of occurrence, the village people informed me over phone that Ganesh Monkey Munda beheaded one person. I informed at police station. I went to the place of occurrence and saw the beheaded dead body of the deceased. The head of the deceased was found in the house of a relative of accused. The dead body sent for postmortem examination. Magistrate had inquest over the dead body and obtained my signature in the inquest. Exhibit 5 is the photocopy of the inquest. This is photocopy. I1 is my signature. I did not investigate the case. I only present at the time of holding inquest. PW10 is Lordship Sitangshu Kumar Kaur. He is the investigating officer. On 14/3/16, I was posted at Majbat PS as second officer. On that day at around 6:15 a.m., I was at my police quarter at Majbat PS. At that moment, I received a telephone call from the officer in charge, SI Dipu Bora of Majbat PS, informing that a murder took place at Jagyapur, which was informed to the officer in charge of Majbat PS by ASI Dulal Chandra Das, in charge of Jagyapur PP, and I was accordingly asked to proceed to the place of occurrence. Then I immediately rushed to the place of occurrence with armed police party, and when I was proceeding, the police officer in charge, Majbat PS, again rang me up and informed me that another murder had also taken place at number 1 Khamtubari under Majbat PS. After proceeding a little further, we saw a huge gathering of people at number 1 Khamtubari and went there. Immediately, the village headman of that village, Bhadreswar Panika, came to me and informed me that one head of a human being has been kept under a bag in a bicycle wherefrom blood was seeping out in the veranda of the complainant, Him Orang. Then I proceeded there, and after opening the bag, I found one head of a human being with gray hair, and the entire bag was stained with blood. I also saw blood marks falling on the ground towards the western side. Accordingly, I followed the chain of blood marks and found one penis with testicles covered by some gray hair lying there. Then the village people who accompanied me told me that on further western side, one person was lying injured. Accordingly, I proceeded there and saw the injured person with blood in his pants. The village people also told before me that the penis was, as well as the testicles of the injured person, have also been cut. And Indra Bhumij and the informant Him Orang told me that the person is Ganesh Monkey Munda, who is their relative. The injured person was being identified as Ganesh Monkey Munda, who is the accused of this case. I put some questions to him. He replied that he cut his father at his house to death, and after separating his head from the trunk, he brought his head in a bag and carried it to his aunt's house in a bicycle, and the same has had been kept there, whereas the headless body of his father was lying in the house at Jagjapur. I also asked as to how his penis was cut. He said nothing, and on being asked whereabouts of his penis, he told that the same was eaten by pig. On seeing the injury of the accused, he was immediately sent to hospital for his treatment with our constable Mahesh Pushta and other relatives of the accused. Then I proceeded to the house of the accused, Ganesh Monkey Munda, where I saw the headless body of his father, Piyush Munda. I also observed that the penis of the dead body was also removed along with some fingers of his hands by means of sharp cutting weapon. Having found the headless body of the father of the accused, I informed OC of Majbat PS, Circle Inspector Gauri Kantaklokar of Rauta and the Deputy Commissioner Udalguri to deputy magistrate after narrating about the incident. Afterwards, the executive magistrate, along with circle inspector and the officer in charge of Matpat PS, arrived at the spot. At the place of occurrence, I also found one blood-stained axe and a sickle lying inside, beside the headless dead body with stain of blood. I also seized one hero bicycle at the place of occurrence. I also prepared one sketch map of the place of occurrence. The village people identified the headless dead body was of Piyush Munda, who was staying with his son Ganesh Monkey Munda in a small house. The village people also told me that accused used to quarrel with his father regularly regarding sale of their land while they were staying together in that small house. At the spot, the executive magistrate conducted inquest on the dead body of Piyush, and thereafter the head as well as the headless body of the deceased was sent for postmortem examination. Later, the injured accused was referred to Tezpur Medical College and Hospital for his treatment. On 34/16, the accused was released from hospital. On the same day of the incident, Him Orang lodged the FIR before the officer in charge of Mazbat PS regarding this incident. As I conducted investigation of the case on the basis of GD number 286 dated 14/3/16, and after a lodgement of the FIR by the informant Him Orang, I was entrusted to complete the investigation of the case after registering a case by the officer in charge by Mazbat case number so and so under section 302 IP. I recorded the statement of available witnesses at the place of occurrence under section 161 CRPC and conducted the postmortem examination of Piyush Munda. I also collected the injury medical document in connection with this case. On completion of investigation, I laid the charge sheet against the accused Ganesh Monkey Munda under section 302 IPC. Exhibit 2 is the Caesar list of hero bicycle wherein 3 is my signature. Exhibit 3 is the Caesar list of one axe with handle and one sickle. 3 is my signature. Exhibit 6 is the sketch map. 6-1 is my signature. Exhibit 7 is the charge sheet. 7-1 is my signature. Though I received information relating to 2 murder cases from 2 different sources of police while I was proceeding to the place of occurrence, but later it was confirmed that both the information related to the incident of the instant case. In cross, he says, on being questioned, the accused told that he also cut his own penis from after beheading his father and cutting the penis of his father along with testicle, and which was later recovered by me. I did not record the statement of some of the witnesses residing near the place of occurrence. Lordship, this is the evidence. And then we have the...
There is no serological test.
No.
The sickle and the axe which were seized. Admittedly, those were seized.
Seized.
There are 2 Caesar witnesses.
2 Caesar.
Those were not sent for forensic.
No, they were not sent.
Blood was not.
No, that
not
was
even a
not
test done.
And Lordship, in the court below, the advocate for the accused, he argued on 2 points. One was the medical condition of the person, Lordship. Because in cross-examination, one...
Yes, he has taken to mental hospital.
That has come.
Yes.
But then Apex Code, certain judgments are there, Lordship, and Apex Code, what Apex Code says, or what is the legal, is that we need to have the legal insanity, not medical insanity. So, Lordship, looking at the, I do not know whether, because there is no eyewitness. But then again in 313, he has accepted. But the corroboration, with 313, there has to be a corroboration of the evidence of the witnesses. Lordship, one question comes to my mind, whether this person needs some medical help. apart from what he is here, because in his 313 he again says that out of repentance he cut himself, his parts, he had cut himself those parts because he felt repentant that he had killed his father. But killing his father, if he did it, Lordship, beheading, cutting fingers, and then again private parts.
No,
So-
repentance, what repentance?
No,
Here,
that-
of the dead body itself, it is not causing injury to yourself. It is causing injury at severing parts of the dead body itself.
no, to his part also. He also suffered. That
What kind of injury? Where is the report?
he cut his penis.
No, where is the report?
No, that is why the IO said, Lordship, that he was taken and on 34/16 he was released from the hospital. Because the incident took place on 14/3, Lordship.
No, where is the medical?
No, that was not produced.
No, that is not. See the deposition of the doctor. PW6.
Doctor says about the deceased
This is,
only.
come to this thing, 17, more detailed description, number 3. It is of the deceased.
No, accused also. The witness. Huh? No. This is about, this is what he did to his father, whatever. But to himself also,
From where do you get this?
the witnesses, Lordship.
Number?
One also says,
One?
Lordship. Just
No, one does not say.
Yes, Lordship in cross, Lordship. While police was asking him about the occurrence, the accused told the police that his private part was also completely cut by somebody. We noticed bleeding from the person of the accused. I did not witness who kept the pen, that is PA.
No. He is not talking about his. He was talking about the father. What is the meaning? Come to the FIR, last line. Huh? No,
But it is about his.
Then there has to be some medical report.
So that the prosecution has, because he was taken to the hospital. IO says clearly that he was released from the hospital on 34, and the accident had taken place in the month of March. On 14/3, the FIR was lost, and he was released from the hospital on 34.
Even PW says so. She was taken to Jeshpur mental.
No, that's
hospital.
mental.
Mental. No, about
But nothing is
About
on record.
the injury. About the injury. He.
Injury part, Lordship.
Other witnesses
have
also
also said.
on the way also they found his penis and testicles.
Lordship, page 9, cross-examination.
Yes.
We notice bleeding from the person of the accused.
PW8 says the blood was oozing from his head.
No, there is a clear statement at page 9. Just the line, Madam Bhuya, just above that.
Yes,
First
Your
line.
Lordship. Yes.
First
Yes.
line of
Police was asking
His
him.
private part was completely
No,
caught
no,
by.
cross-out is the bottom line.
Yes.
While police was asking him about the occurrence, accused told the police that his private part was also
Completely
completely
cut
cut by somebody. We noticed bleeding.
There
from
was
the
no
person.
medical.
No, there was Lordship. IO says that he was hospitalized because of his
Your Lordship,
injury.
permits, I can see
Not a
that.
medical report. Taking him to medical will not do. Was there
Yes,
medical?
at the time of arrest, whether any medical, medical should be done. Yes. Okay. But it was not brought on record, my.
Then in the postmortem, what about the description of the injuries on the body of the deceased?
It was neck, it was severe,
Yes.
and right hand finger, two finger,
Private parts were cut off.
private part. Both the people, he cut off private part of his father as well as his own. That's why the witnesses, that's why he was bleeding, Lordship. They trailed the blood because he was bleeding, the accused.
Lordship, it's there, but it was not brought on record.
It is there.
Yes. LA's, so suicidal injury, total amputation of penis and psychiatric disorder.
So this report was there.
But it was not brought on record. Lordship, can you have the pictures?
Like, we call it mental health.
How was the mental insanity or legal insanity dealt with?
Lordship, we go for section 84, Lordship.
84?
84, Lordship.
No, how was it dealt with in the judgment?
The learned trial court.
Or trial court, Lordship, discussed it, but I'll Oh. 59, paragraph 59 of the judgment, Lordship, page 58 of paper. Mr. Torun Chandra Boro.
Yes.
Mr. Torun Chandra Boro, learned counsel for the accused, submitted that at the time of incident, the accused was suffering from insanity, and therefore he entitled to get the advantage of section 84 of IPC. But I find no force in the submission of the learned counsel for the accused to accept his contention in view of the fact that there is not even a scoop of evidence on record to prove that accused at the relevant time was incapable of knowing the nature of the act and that what he was doing was either wrong or contrary to law. There is also no evidence to prove that accused was in a proper
Not in a probably
not in a proper state of mind at the time of causing death of the deceased. Admittedly, the defense has not taken plea of insanity at the time of trial of the case under section 84 of IPC. The burden of proving that the mental condition of the accused was not proper at the time when the offense was committed lies on the accused in view of section 105 of Indian Evidence Act. Lordship, but in view of the medical report, Lordship, psychiatric disorder is mentioned there. The court was also duty bound to, and prosecution was also duty bound to exhibit that document, Lordship. When IO said that he was hospitalized and was released on 34.
How do you take a defense of insanity at the time of trial?
That is true, Lordship.
Now, how do you take?
We prove if we had, because here one question came that he was taken to Tezpur Medical. So
No. So far as the observation made by the learned judge, admittedly the defense had not taken the plea of insanity at the time of trial of the case.
That document was with the court itself. So how do the accused?
No, madam, how if a person is insane and is put to trial, how do you take the plea of insanity? What is the procedure?
Procedure is, Lordship, naturally defense because the in cross of the PW1 it has come that he was taken to hospital.
Madam, not on
So
the
that
merits.
document.
How do you introduce the plea of insanity? You are the defense.
Yes.
There is no question of filing any pleadings. It has to go in the form of suggestion.
And suggestion was that
Or at
question.
best, DW.
Lordship, I've gone for the order sheet. Order dated 5/5/16. Seen the report of jail superintendent Udalguri dated 5/5/16, wherein he had paid to shift the UTP Ganesh Monkey Munda to Central Jail Guwahati for better treatment. He further reported that presently UTP Ganesh Monkey Munda is undergoing treatment at GMCH Urology Psychiatric Medicine Department, but still his condition is critical. Had seen the medical report, considering the gravity of injury and the fact that there is lack of proper medical facility in Udalguri Civil Hospital, I find merit in the prayer of Superintendent District Udalguri, and prayer to shift UTP Ganesh Monkey Munda on medical ground is allowed. The Superintendent Central Jail Guwahati is asked to cooperate and keep custody of the UTP Ganesh Monkey Munda for 12 days. And so then.
Was before the court, Lordship. That court can, in fact, in cases so moto, court can take up, because if he is himself insane, Lordship, how does he educe himself? How does he?
Medically. এটা দরখাস্তখন কোনে দিব এইটো দিয়েছে না এইটো স্টেট কাউন্সিল আছিল নহয় জানো তাৰ সেইটো ডিফেন্স নাছিলে এইটোটো জেল এপিলত কোন was he represented by a council of his choice or state defense? State defense
সিহঁতে ক'ৰ পৰা এফৰ্ড কৰিব পাৰিব নোৱাৰে।
state defense কিমান দূৰ কৰিব নকৰিব
Learned advocate
Unable to engage the lawyer.
judgment order speaker চিকিৎসা নেকি ইয়াতে কিন্তু learned advocate
He stayed with his father only. Till his father, no one is there. Most probably state defense was there.
Yes, my lord, I have found somewhere, but he cannot engage
the
the lawyer.
judgment it is written learned
Lordship,
advocate.
there's an order. On being asked, the accused person stated that they have not engaged counsel for their defense, and learned counsel P. Baski is appointed for his defense.
Because ইয়াতে আছে Mr. তরুণ চন্দ্র বড়
Medical to support.
Lordship, in one case, what happened, it was something like that, very gruesome murder in our High Court. I argued the matter and the appeal was dismissed, but then I prayed to the court that at least the accused may be shown to a doctor whether he is insane. Lordship, that was allowed, and the case was of Lakhimpur, and then when he was examined, it was found that he is truly insane. Then the Lakhimpur police, they have sent me a letter. Then I filed a IA in the court, and this person was sent to the Tezpur hospital. I have the orders also in that case. And
Hmm. 84 comes under general general exception. Sorry, American. India. No, IPC law.
No plea was taken here.
He has just in the argument stage
Yes.
at paragraph 59.
Lord.
That was the only
Yes.
scope of rather it is seen that he was trying to introduce 84 at that
Yes.
stage.
So I've seen the report received from the jail authorities, my lord. It's on medical ground. not about his mental health.
But then factual,
কাটি দিয়ে না? Page number, yes.
Neurology, medicine, all medicine or
What was the age of the deceased?
five. Accused 29. Sir, একটু লিখলে please, একটু
Lordship 60 years as per the inquest report. Yes. One document I found my. It's from the Superintendent District Jail Udalguri. With reference to the above, I have the honor to state that on 29/9/16 at about so and so, head wardens on duty brought UTP Ganesh Monkey Munda to jail office and reported before the jailer that the state UTP suddenly punched life convict AC so and so Ranjit Roy from backside without any reason. On asking why he did it, he again tried to attack one of our guarding staff, and a little manhandling took place to try to stop him. In this connection, it is pertinent to mention here that the state UTP has been undergoing medical treatment at Psychiatric Department of GMCH Guwahati since 21/4/16. Photocopy of the medical enclosed here. Lordship, for end of justice, Lordship may direct us take a report from the jail authorities as to its present.
No, if you see the definition of unsound mind
Lordship,
under general exception
my lord,
IPC,
my lord.
chapter 6, I think, chapter 4. Chapter 4, 84 says,
nothing is
it says, nothing is an offense which is done by a person who, at the time of doing it, by reason of unsoundness of mind, it doesn't end there, is incapable of knowing the nature of the act or that he is doing what is either wrong or contrary to law.
Well.
He should be in a position that he doesn't know what is the nature of
Yes.
the act and what are the, whether it's barred or it's a wrong act or contrary to law. Here it is not like
Nothing.
that. Rather in the 313 statement, he says that I have done it. That is not a legal insanity.
That's what I was saying, that in 313, he's accepting everything. But then, Lordship, the reports from the hospital and Lordship, won't he be like a threat to other
No,
inmates?
that's a different aspect from the perspective of the examination of this conviction and sentence.
Hmm.
What for what other measures we may direct, that's a different matter altogether. But whether he would come within the definition of 84.
That is true, Lordship. No plea was taken and no evidence to that effect. Because if the
No,
record,
irrespective of the plea, we are in an appeal. We can still
Hmm.
appellate stage. We can still direct his examination or accept this plea.
Yeah.
But whether this plea would be on the face of it, whether it be applicable.
yes,
In
Lordship.
313, he knows the consequence.
Yes, 313 is later on, Lordship. His condition has to be at that point of time, whether he knew. That is the yeah. The question is regarding the crucial point of time at which unsoundness of mind should be established is the time when the crime is actually committed. But again, the burden of proving which lies on the accused in order to entitle him to.
No, these
to the-
general exceptions are very, it should be applied in rarest of rare cases. Otherwise, everyone will say that I did not know what was going on
Correct.
at that time.
But Lordship,
But having
looking
said
at the
that-
gruesome.
Having said that, at this point of time or at a later point of time, to know his state of mind at the time, you can only come with some plea or some evidence at later point of time.
That was not
See,
there.
the prosecution has led evidence. No one will say that he was suffering from unsoundness of mind. He did not adduce DW. No, we don't find any suggestion at that time. But at the time of argument, this was introduced, and what
One
we can
question.
find, 313, how did he answer the questions?
There he is confidently giving. That's what.
Let us
Only
read-
one question was there, only about the elder brother had taken him from it. And also, Lordship can look into the fact that from the hospital, from the jail, he is getting treatment for his mental condition. So, but the trial court did not look into that part, and neither did the counsel. So, in argument stage, we mentioned that he should have, in fact, had he brought in those records also, it would have done. Had he pointed out those records from the court record.
Lordship, section 328 and 329 of CRP.
Three,
328, procedure in case of accused of being lunatic. Then the 329, procedure in case of person of unsoundness of mind tried before the court. If at the trial of any person, as the Lordship counted, 329 CRPC. If at the trial of any person before a magistrate or a court of session, it appears to the magistrate or a court that such person is of unsound mind and consequently incapable of making his defense, the magistrate or court shall, in the first instance, try the fact of such unsoundness and incapacity, and if the magistrate or the court, after considering such medical and other evidence as may be produced before him or it, is satisfied of the fact, he or it shall record a finding to that effect and shall postpone further proceedings in the case. If during trial the magistrate or the court of session finds the accused to be of unsound mind, he or it shall refer such person to a psychiatrist or clinical psychologist for care and treatment, and the psychiatrist or clinical psychologist, as the case may be, shall report to the magistrate or court whether the accused is suffering from unsoundness of mind. Provided that if the accused is aggrieved by the information given by the psychiatrist or clinical psychologist, as the case may be, the magistrate he may prefer an appeal before the medical board, which shall consist of so and so, so and so.
328.
Then two, my lord, if such magistrate or court is informed the person referred to in subsection 1A is a person of unsound mind, the magistrate or court shall further determine whether unsoundness of mind renders the accused incapable of entering defense, and if the accused is found so incapable, the magistrate or court shall record a finding to that effect and shall examine the record of evidence produced by the prosecution, and after hearing the advocate of the accused, but without questioning the accused, if the magistrate or court finds that no prima facie case is made out against the accused, he or it shall, instead of postponing the trial, discharge the accused and deal with him in a manner provided under section 330. Provided that if a magistrate or a court finds that prima facie case is made about the accused person, in respect of whom a finding of unsoundness of mind is arrived at, he shall postpone the trial for such period as, in the opinion of the psychiatrist or clinical psychologist, is required for the treatment of the accused. If the magistrate or the court finds that a prima facie case is made out against the accused, then he is incapable of entering defense by reason of mental retardation, he or it shall not hold a trial and order the accused to be dealt with in accordance with section 330.
Maybe I need to get my credit. That's what people talk. But yeah, photo of a state digital section requires that they are quite so the court had thing in front.
Page, page 29.
Report actually. Review of the
Question number 21.
before here, like
What is
it was
it?
They can put one. Like, okay. Eight to target that included. In the Saturday. That is also there.
Pharmacist is prescribed is suffering from schizophrenia. Lordship, can it be taken up in the coming week on Monday? This bench probably will be available.
From the manner by which he has answered 313, which my learned sister has pointed out, he knew about the consequence, but this kind of answers, can it be given by a sane person?
It is too true to be.
What is legal insanity? What is medical insanity? Legal insanity has to confine, it has to be confined to 84 definition. By reason of unsoundness, he is incapable of knowing the nature of the act. I do not know what is the consequence. or what he is doing is either wrong or contrary to law.
law. His post act also.
He knew that when he had used the axe to cut off the head, behead, the person will die. He was aware of the consequence.
But then Lordship, since documents are there in the file itself that he had to be taken to psychiatric care. আৰু
এই দুটা বস্তু আছে 320 বেছি খাটে কিন্তু 320 অকল মেজিষ্ট্ৰেটে ইনকুৱাৰী কৰাৰ ক্ষেত্ৰত আৰু 329 ট্ৰায়েলৰ ক্ষেত্ৰত মেজিষ্ট্ৰেট এজ ৱেল এজ কোৰ্ট অফ সেশনস it appears to the magistrate, it appears definitely offense to এনেকুৱা দেখি এটা হেৰি ফাৰ্ষ্ট ষ্টেটৱে ল'ব লাগিছিল it was an explore
313 statement. 313 statement was taken on 14/11/18 after 2 years. In the meantime, he was taking certain treatment and
And his condition is stated to be stable. I found one certificate.
presently
that is after the treatment because he was given treatment. So in that more than 2 years, because the incident took place in March of 16 and this was taken on 14/11/18. 2.5 years of treatment has been given. So now what he is saying in 313, and what was his condition at that point of time, Lordship? Since the session judge had the information before him that he was not stable.
Madam, is there any order in the order sheet? Do
My
you have
lord.
the records
My lord.
that during the trial, at the initiation of the trial, he was sent for medical examination?
Yes, ma'am.
Then it may meet the requirement of 329.
Excuse me.
এইখিনি কিন্তু তেজপুৰৰ মানে তেজপুৰ মেডিকেল কলেজ যে হেৰি নহয় লোকপ্ৰিয় গোপীনাথ বৰদলৈ মেণ্টেল ইনষ্টিটিউট নহয় তেজপুৰ মেডিকেল কলেজ তাতে ওদালগুৰিত আছিল না This is of which district? Udalguri?
Udalguri. He was sent to GMCH because
No, initially he was sent to Tezpur Medical College. Not LM Lokanath Gopinath Mental Institute.
No. Then
it was the normal medical college. It was psychiatric department.
The report is
There's a order 1/12/16, my lord. It is informed that the accused are undergoing treatment at Guwahati Medical College Hospital, Urology, Psychiatry and Medicine Department as Indo patient. UTP requests regular review checkup at GMC for proper medical treatment. It is further stated that as per advice of GMC's authority, UTPs need to be produced before GMCH, but the production of is difficult considering the distance of GMCH from Udalguri. It is mentioned that there is no permanent doctor to look after them. There he was shifted to GMCH, my lord. Regarding the psychiatric. Okay. I got it. order আছে।
Treated industry যে কাটিছে যে একটু একটা
আজিকালি এনেকে দিয়ে নেকি এই মানে ইমান বছৰ আছে নেকি এইটো 8 বছৰ আছে যে মই এতিয়াও মন কৰিছো কি এইটো ৰেগুলাৰ আপডেট হয় নেকি মানে কি কম্পিউটাৰ হৈ যায় নেকি হেৰিত মেচিনত কৰা আছে নেকি এইটো মাৰি দিয়ালে বোলে ডি ৱাইজ মানে সেইটো বাঢ়ি থাকিব
Okay, so
But.
সেইবিলাক একটু সেই কনচিকুৱেঞ্চটো জানা বুলি ক'ব নোৱাৰে মৰা মানুহ আঙুলি আৰু কিয় কাটিব নে তাৰ নিজৰ ঘৰ বাহিৰৰ পৰা লগ কৰা আছে মোৰটো কাৰোবাৰ হেৰিত কমিউনিটি ঘৰ বেগ এটাত পাইছে চাইকেলত পৰি আছে
সেই argument আছে
on learned trial could did not take into account all those fees. Only there are medical reports to that effect. But regarding, there is nothing on the auto sheet, my lord, regarding mental.
that he was shifted to Guwahati jail also, central jail, because of his treatment. That is also mentioned. But no consideration of
What
the
Madam
document.
Bhuya has referred to 329 does not envisage that an application is required as a precondition. Whenever it appears to the magistrate or the learned session judge that the person facing the trial is of unsound mind,
And consequently incapable of making his defense.
then it's not required that some application is required to be
Or to
filed
prove.
or filed that he is suffering from or he is a person of unsound mind. If it appears to the magistrate, that is enough. Whom he can take up, or the learned
But the
session.
documents were there before the
in-
magistrate.
in-
Syncophrenia is
yes.
mentioned there.
And moreover, as you said, the documents were also there.
At least he should get treatment and others should not be. My PA is that he committed, he did not commit, that apart, lordship. Because of him, others again should not die. And he should also get
No,
a.
as on today's, he is stable. What Madam Bhuya has, some document is there.
No, court has written.
Yes,
Document.
he is stable.
Doctor document in the court or auto sheet or that he is suffering from epilepsy.
No, you said that as on today, as on subsequently, he is stable.
Yes, my lord.
There's
That
a
is there.
document here.
Yes. Documents are there, but I didn't find it in the auto sheet regarding his.
No, but
mental-
document is there.
My lord, documents are there. But,
একটু তো ট্র্যাক করি তুমি ডকুমেন্ট তার লগত অর্ডার কৰি
এইটোতো হেৰি এটাক কৰি কৰিব okay থাকাত
Have you checked the entire order sheet?
yes
No such.
no let me have a look once again
ডকুমেন্টৰ লগত মিলাই চোৱা produce
আজি নহবই চাগে এইটো এনেকুৱা হৈছে Hmm? What was it? What
Are-
was it? Mr. Sharma, which matter are you waiting for? No sense.
One, I found a lot in the paper book.
No report.
Actually, it is not published. One thing is missing lot.
It is not?
One vital document written that missing lot, found missing. So one was trailing is the circumstantial evidence matter. Trailing lot. I did not find the record also. So I'm triggering a trail lot. So I want to trace that our treatment register by Francis lot.
Today it may not be possible. And even if we hear for some moment, this bench will not be there in the next week. You can try on Monday or Tuesday, you can try. And we do not know what we'll do with this matter. This is also
Lordship.
become slightly.
Found one order,
Yes.
11/1/18.
Hmm.
Accused Ganesh Monkey Munda is not produced from custody. Report as called for has been received from the Superintendent Central Jail Guwahati. Doctor of Central Jail Guwahati reported that at present medical condition of Ganesh Monkey Munda is stable.
Hmm.
Hence it is directed to produce.
What is the date?
11/1/18.
11/1/18. And the incident is of 16. March 16, almost after 2 years.
We can dwell some more into the legal aspect of this matter, as Cornali was saying. We'll try to. I have one judgment about legal and insanity.
What is it?
But their lordship, they proved it. But the thing is here they.
One lordship, this honorable court dealt with Upen Bosumotari versus State of Assam on legal insanity.
No, the problem, difficulty will be, even as an appellate court, we could have invoked 329, but
My lord.
after a lapse of 8 years, there is no scope now. As on today, he may not appear to be unsound.
But
See?
then we have to look at that point of
So
time.
how do you, at that point of time, is it possible today?
No, because of the treatment given and because of the fact that
No,
the
madam,
trial
you're not on that line. You're going to a different tangent. The purpose of 329 is to ascertain
at that point of time.
whether because trial starts immediately. Immediately after the investigation, filing of charge sheet, framing of charges, denial, trial starts.
So then, lordship, it is a mistrial because the court did
On
not
trial
look into.
starts, he is produced before the court. It might appear to the court that he is a person of unsound mind. So you invoke 329. The same thing we could have also invoked, but see the lapse of time, the flux of time of 8 years. As on today, he may not look unsound. And as on today, it will be difficult to know his position, state of mind 8 years before.
That is true, lordship. Then that becomes, lordship, since the trial judge had those information before him, it is a mistrial then. Because the trial judge had the information, he knew that the
Then
person was only.
If you're on this line, then you have to make out a categorical case that yes, he was a person who was legally unsound and gets the benefit of 84. 84, though it's under general exception, chapter 4, but its application is very limited.
I
Otherwise,
understand
the
that.
precaution, the caution, in fact, caveat has been given by the Honorable Supreme Court. Please be very careful in invoking this. Otherwise, everyone will take the
Correct.
plea of insanity.
Correct.
In one of the cases, which was that case? That 72 case, I get to some. Get to another. Difference.
The judgment I have given Lordship in paragraph 20, the last, the second para, the doctrine of burden of proof. It- তাতে অ, তাতে মানে অ, লিখিম। তাতে মানে it's not necessary that to give a full evidence তাতেতো দিছিল কিন্তু ইমানো দৰকাৰ নাই কোৰ্টে কৈছে দেখুৱালেই হ'ব so the records were there but at that point 18 or 3 is okay at that point of time he was not
Do you have a search mechanism, something? Can you,
Yeah.
AIR 1972? Party's name is not very,
1972
AIR 1972, Supreme Court.
Hmm.
2443.
M uh, Justice SM Sikri
Yes, yes.
A.N. Ray
Yes.
plea of insanity proof
Yes, yes. That some
getting
observation
the
has been
full-
made.
getting the Sherali Wali
Yes, yes,
Muhammad
yes.
versus State of Maharashtra.
yes,
Yes,
yes.
Lordship. I got the judge charged with offense under 302 of Indian. I'll read. Lordship.
Yeah, no, that there is some,
Accused file an appeal against the conviction. The appeal special if the prosecution case was the spot of. Then the injured person was taken to jail. Plea of accused is that at the time when the injured person caused by him was not the accused could agree to the fact that it's not in a
There-
sound mind. 9, paragraph 9.
there is
that
a note of caution.
As of this status, the evidence of paragraph 9. Two defenses were taken, not there, as well as evidence done by are not clearly that at the time of the appellant by reason of was capable of the nature of the act, or that the acts were either morally wrong or contrary to is there evidence to show that at the time of slavery any such enterprise? On this question, the state of his mind before or after the commission of the offence is relevant. The general burden of proof that an accused person is in a sound state of mind is upon the prosecution. So basically, the prosecution has to prove that the accused was in state of mind, in proper state of mind. Prosecution must prove beyond reasonable doubt committed offences that is the reprisal.
Yes, see the last paragraph. We think. Found it. We think.
With this in mind,
No, we think. Thereafter, the sub-para. His evidence has not been challenged in the cross-examination. We think that.
we think that
Not
we think
only-
that not only is there no evidence to show that the accused was insane at the time of the commission of the act attributed to him, but that there is nothing to indicate that he had not the necessary mens rea when he committed the offense.
No,
The
next
law
line.
presumes that every person of the age of discretion to be sane unless the contrary is proved. It would be most dangerous to admit the defense of insanity upon arguments derived merely from the character of the crime. The mere fact that no motive has been attributed, no motive and character of crime, the mere fact that no motive has been proved, why the accused murdered his wife and child, or the fact that he made no attempt to run away when the door was broken open would not indicate that he was insane or that he did not have the necessary mens rea for the commission of the offense. We see no reason to interfere. Yes, Lordship, here I would like to distinguish between our case and this case. Lordship, two things. That's the character of the crime
Yes.
and also that motive. I did not go by, because the documents which were present before the trial court, Lordship, that he was taking treatment, the court itself was sending the accused to take treatment, Lordship.
No,
The-
the primary reason for sending him to the medical was not for his insanity. It
Oh,
was
that time
mainly for
because-
the physical injuries
Huh.
which was found on his body.
Yes.
And while going there, he was also examined by a psychiatrist where some psychiatric disorder was also found.
Huh.
Correct.
Correct.
But-
That is what I'm harping on. That
But
how
it's not that he had gone there. The learned minister or the learned session judge from cursory of bare look found that something was wrong with
that
him.
we cannot
That
do. That
He
in
was
fact-
found to be bodily injured.
Yes, and in fact, before sending him to the trial, he was sent to the hospital as per the IO's.
Yes, because he was bleeding.
Because he was bleeding, he was injured, and there it was clear that he had psychiatric problem. So, Lordship, I'm not in this case. Lordship mentioned the case. There is two things: that character of crime and no motive.
Here also, the nature by which the offense has been committed, whoever is committed, beheading a person, taking his head, and if it is by the son, that itself is not only gruesome, but it's something which is cannot be even
Out of
cannot
the,
be even thought about.
out of
Then
thinking.
cutting
But
private parts.
then, Lordship, if I come to that, Lordship, there is no eyewitness.
No,
so
no,
to
that is
say.
okay. But
Huh.
no, no, these are facts.
Hmm.
Whether he has done it or not, that's a
Yes,
different matter. But these are
that is
facts.
that is also not proved by the prosecution directly, that yes, because his confession, Lordship, that's why I said before the police. And again, it is hit by section 25.
No,
No,
that
no,
is
that-
there, but
that-
before and other
313.
two persons also he deposed it,
Huh.
my lord,
See-
and it has also come up on record. They used to quarrel because of the land dispute, my lord.
No, but the
Regularly they used to quarrel.
proposition of the aspect of extrajudicial confession will definitely examine from the perspective that is a weak piece of evidence
Mhm.
without corroboration.
Yeah.
Before police, it is barred,
Barred,
not even
totally
taking into But there are, what Madam has pointed out rightly, there are two persons have said that even before us he has said. And why? There is a motive, there is a land dispute, there is the frequent quarrel. And he also repented of killing, but the manner of killing, taking the head, but the X should have been, or at least the sickle should have been sent for
Examined.
serological, at least minimum forensic examining whether it was used by him or whether the blood stain, because those are seized.
Hmm.
Seizure list contains sickle and X.
X. And the bicycle also.
Bicycle.
Whether the blood on the bicycle
Now, if
also
a
has
weapon is seized and not sent for forensic, what is the
use of
use of having a seizure
Seizure.
of a weapon?
weapon.
Seizure of any other things is okay.
And when they say that blood was there,
There, yes, it was
when
stained with blood.
specifically there, the witnesses are saying that, so Lordship, if we go by the merit of the case also, then also I think the prosecution failed to prove that it was him and him only who did the thing, that the chain of, yeah. But at first what he said is someone else had cut him his private part and all that. But, and also this part, Lordship, that if he did not know.
What about 313?
313 is 2018, Lordship. 2018, within which from 2016 till 18 January.
No, if you are taking generally on the merits on as a case of circumstantial evidence, you are trying to make out a case that it doesn't come into those 5 principles.
Yeah.
There may be the involvement of somebody else, or there may be.
No, I'm not saying somebody else.
Somebody
But what I'm saying is that prosecution failed to prove that this particular person only did. That is what.
That is it. That means there may be, if you are
But then-
successful, if
but
you are
then
successful in
if he
raising.
is psychrophonic, Lordship, then for him, that other person might be someone, for he himself, Lordship, what I could understand from psychrophonic people, they have double characters, Lordship. That other person might have done something. And then the Mr. Hyde came out and he is repenting, but the jackal did the thing. That is what I'm trying to say, because of his medical condition. I don't know how much.
313, after he recovers, he's in a fit state of mind, he has given the 313. But Lordship, even he could recollect whatever had happened, and he admits that the Lordship may take into account, my lord. He has not denied.
Given the statement in a state of.
Fit state of mind.
In that case also, he could have said that, I don't know what had happened.
Yes,
that
my
I
lord,
know
those
what
pleas
had
he has
happened,
not taken.
and his statement is otherwise.
Yes,
That's
my
it.
lord. Yes.
But Lordship, based on 313 only, a person
No,
cannot
no,
be
no,
convicted.
no,
Huh.
That is,
If you see the
I'm
reply
just-
and the, questions of the.
yes,
313,
he is giving very good reply, even maybe better than any advocate could have given a reply. The way he's explaining everything there, why he did and what he did. Because it is clear, yes, on the day of occurrence, I beheaded my father in my home by means of an axe, and thereafter carried the severed head in my bicycle and kept the said bicycle and the bag containing the head on the veranda of Bhim Orang, who is my relative. I stayed with my father in the same home, and I had frequent quarrel with my father, who wanted to sell his land without giving me any share thereof. Question
So
number
those-
1. First question, he's giving detail of everything.
And those pleas, the other witnesses have also deposed, my lord, the land dispute, frequent quarrel.
Stop, can you whisper? Everything is mentioned there. Head, home, eggs, bicycle, Bhim Orang. frequent
The answer
but-
in question number 21, it's very dangerous. 21 and both 23 also.
Yes, I am Ganesh Monkey Munda and my penis was cut by myself as I wanted atone from my sense of committing murder of like he repented. That is what at that point of that is why I'm saying that when he committed the crime on his father, at that time whether his mind was clear. That is what my more case put into all of this, the judgment I've submitted, Lordship, paragraph 20, I'll just read that I submitted the second case, Lordship. Paragraph 20, second part. The doctrine of burden of proof in the context of the plea of insanity may be stated in the following proposition. 1. The prosecution must prove beyond reasonable doubt that the accused had committed the offense with the requisite mens rea, and the burden of proving that always rests on the prosecution from the beginning to the end of the trial. 2. There is a rebuttal presumption that the accused was not insane when he committed the crime in sense laid down by Section 84 of the Indian Penal Code. The accused may rebut it by placing before the court all the relevant evidence, oral, documentary, or circumstantial, but the burden of proof upon him is no higher than that rests upon a party to a civil proceeding. 3, Lordship, I am on 3. Even if the accused was not able to establish conclusively that he was insane at the time he committed the crime, the evidence placed before the court by the accused or by the prosecution may raise a reasonable doubt in the mind of the court as regards one or more of the ingredients of the offense, including mens rea of the accused, and in that case, the court would be entitled to accuse the accused on the ground that the general burden of proof resting on the prosecution was not discharged.
I think it will be better if we again go through the records in a hurried manner. It should not be done.
Yes.
New things have come up.
It's a bit difficult case.
If the exercise was done under 329 at that moment, matter would have been not so complicated.
Yes. Correct.
But it's not a case of split personality. He has not said that I acted by.
The thing is that because that document is that he is suffering from syncopania. That's it.
Schizophrenia is not split personality.
Personality.
Think-
Schizophrenia is not split person. Is it?
No, no, split personality.
Split
Person.
A disorder that affects a person's ability to think, feel, and behave clearly. It's split personality is different thing. Where two personality may be inside the same person. There was a beautiful movie called Primal Fear,
Yes,
96,
Yes.
Richard Gere movie.
I watched it 3 times. And
The other one, I forgot his name. He was a terrific acting. Tabosun Bedo.
you hate him.
Primal Fear.
We hate him like
the-
that
the-
person.
The accused.
Mm.
Terrific acting. Richard Gere took very seriously.
First time we
It
could
was-
not make out. Like he was really into something.
When do we fix this matter? You'd like
As-
to do it immediately. This bench may not be there. If you
As
want to,
Lordship pleases, Lordship.
no, we'll have it in the next week. some other bench will be there, but if,
No, we, Lordship, heard the
no,
matter.
this bench is uncertain to sit again. This is not a
Then
regular,
when it is sitting, Lordship,
they are
let it
not a
be part-
regular, it's not a regular bench.
let it be parted when it comes,
Will
Lordship.
know, you'll be suffering, you are in jail. Paucity of time, Puriba. List after a week,
Not after that. week,
list
Lordship,
after 2
2
weeks.
weeks, yes, Lordship.
As requested, possibility, no, as requested, list after 2 weeks. Okay,
Adios.
thank you. And wish you, not all of you, 4 of you,
Happy Diwali.
happy Diwali.
Same to you, Lordship.
Okay, এটা